Good morning. It is now 9:21 a.m., April 11, 2013, and I would like to call the Tennessee Board of Examiners for Land Surveyors meeting to order. First order of the business is I will read a public meeting statement into record. This regularly scheduled board meeting is taking place in Conference Room 1-B of the David Crockett Tower, 500 James Robinson Parkway, Nashville, Tennessee, and notice of this board meeting was posted on the Land Surveyors Board website duly noted, on March 21st, 2013. Okay. The first thing that the chair would like to address before we continue is the chair would like to apologize to the members for the lateness of your getting the agenda. I do not know why that occurred. Since I have been on this board, I have prided myself in having the agenda to the members 2 to 3 weeks prior to the meeting, so you'll be able to review, know the items that we're discussing, and research and so forth if you need to for those items. So the chair apologizes to the members, and we'll definitely find out what the issue with this matter is, and it will be corrected before the next meeting. So I wanted to make that statement to you all. Okay, moving forward, the next item on the agenda is to adopt the agenda. We have a couple of amendments. Ms. Mulder has asked that she be able to give the director's report prior to our legal report. We'd like to make that amendment. She has an appointment this morning. She needs to attend for a few minutes and would probably come up about the time that she would be on the agenda. So we'll let her do that. If it's all right with the board, we'll vote on that directly. Also, I would like to amend the statement that says review minutes of previous meeting to also include the minutes of the TAPS roundtable discussion. We actually have two separate minutes documents that we need to review and approve. And also, if there's any other amendments that any of the members would like to make to the agenda. Hearing none, then the chair will accept a motion to adopt the agenda with the discussed amendments.
So moved.
Second.
Okay, we have a motion and a second. All those in favor?
Aye.
Opposed? Okay. All right, we've now adopted the agenda. So the next item on the agenda will be for the members to review the minutes of our previous meeting. And we'll do those first. We'll do those one at a time. The previous meeting will be the first review.
something else out there. Yeah.
If the members have reviewed the minutes from our previous meeting, the chair will entertain a motion to approve if there are no amendments.
Make the motion that we approve the minutes for the last meeting and TAPS convention.
We're going to review those separately.
Okay,
too.
okay.
We'll review those next.
I'll second to.
As read.
Okay. We have a motion and a second to approve the minutes from our previous meeting. If there's no further discussion, all those in favor?
Aye.
Opposed? Okay, those minutes are approved. Now we'll review the minutes for the TAPS roundtable.
Mr. Chairman, I make a motion that we approve the minutes at the TAPS roundtable as read.
I'll second it, but I have a question. On the second page, is testing.
Yeah.
And I told them that it would be effective January the 1st of 2014. So once an applicant is approved by the board, he or she will be able to Pearson View.
Should say go, shouldn't it?
It should be go to someplace to Pearson View. It's a test center, and probably ought to indicate that go to.
With you, Sue? Okay. Okay. Any other amendment, Galen?
Right now, I don't see anything.
Okay. Sue, will you then amend your motion to the,
I make the motion that we amend the minutes of the TAPS roundtable to what Galen discussed, about going to the Pearson Site Center to take the test.
we have a second on that, Galen?
A second.
Okay. We'll vote on the amendment first. All those in favor?
Aye.
Opposed? Okay. Now that we have now amended, we'll vote on approval of the minutes. All those in favor?
Aye.
Opposed? Okay. Minutes are approved. Okay, the next item on the agenda will be the director's report. Ms. Mulder?
Just want to let y'all know our offices are moving back over to this building, 500 James Robertson Parkway, Davy Crockett Tower, on the 4th floor on May 8th, 2013. And we're continuing to work on changes to our continuing education rules. Budget information is on the report for y'all to look at. We have 823 active in-state licensed land surveyors, and we have 333 active out-of-state surveyors. Per the request of the board at the prior board meeting, the definitions for the following are: a 405 survey is an aeronautical survey. A 405 survey deals specifically with airport instrument approaches. And photogrammetry can be defined as the science of obtaining reliable measurements and producing maps by means of photography. Photogrammetric techniques are required to accurately determine relationships of features on aerial photographs, including ground distances and angles, the heights of objects, and terrain elevations. Standard occupational description for a photogrammetrist: collect, analyze, and interpret geographic information provided by geodetic surveys, aerial photographs, and satellite data. Research, study, and prepare maps and other spatial data in digital or graphic form for legal, social, political, educational, and design purposes. May work with Geographic Information Systems, GIS. May design, evaluate algorithms, data structures, and user interfaces for GIS and mapping systems. The following states licensed photogrammetrists and/or GIS surveyors: California, North Carolina, West Virginia, Florida, Virginia, South Carolina, and Oregon.
Have any questions of Ms. Mulder concerning her report?
No, I don't, Donna, but let me clarify one thing. The 405 survey is a survey that I've done some of those, and I think Mr. Lingerfeld and his company has also, but that survey, that nomenclature is no longer correct. The new survey is an airport or aerodrome survey done under the Advisory Circular, or AC, 5300-16, 17, and 18. That's pretty extensive, and it spells out almost the same thing, or maybe even to more detail than what the 405 surveys are no longer in existence as far as the nomenclature. Still the same thing, but under a different title.
Any other comments or questions of Ms. Mulder on her report? Okay, moving forward, Mr. Herndon, legal report.
Okay. Currently have 4 open complaints. One of them first time this has ever happened, at least since I've been around. The dead tree.
You got paper.
That's the one that just came in.
Page 1.
cases?
Yes.
Okay.
Okay, number one is 2013-001671. Practice land surveying in violation of our statute. In particular, the respondent made the appearance of establishing a boundary between the respondent's property and the adjoining homeowner, the complainant, by putting up markers. But no other documentation was submitted to support any calculations or previous location. Plats or field notes were produced, nor was there any apparent attempt to produce and file. Described is pertaining to land surveying. After Okay. Reviewing all this material, what little there was, I came to the conclusion that we can close the case for lack of disciplinary grounds. And as you recall, closing means that if anything ever does become of it, whether a lawsuit or anything, that we can revisit the matter. But right now, there's just nothing there.
Purpose for filing the complaint then, just to say,
It was two private individuals that were upset over the boundary between their properties. Neither one of them's a surveyor. One of them comes over and starts putting up stakes. The complainant called a surveyor. I guess it was a friend of theirs that comes over and he looks at it and says, "Oh, that's not the way it's supposed to be." But there wasn't any work or anything done, and there's no surveyor that was a respondent. The respondent is the neighbor. So there's no evidence of any land surveying in the file. But it would be better to close it just in case. If this ever got litigated and something came out of it, we could revisit it if we had to. Have you ever seen a situation like this before?
oh yeah. Yep.
Any other questions of Mr. Herndon on this issue? Good. Okay. Hearing none, then the chair will take a motion as to the disposition of this matter. Motion and a second to accept Mr. Herndon's recommendation to close the case for lack of disciplinary grounds. All those in favor?
Aye.
Opposed? Okay.
Okay, the second one is an oldie but goodie. This is its third visit to the board, I think. Case number is 2013-005051. And the complaint alleges the respondent, who's a licensed land surveyor, committed misconduct or provided services incompetently in preparing a plat adjoining the complainant's property. Alex here, I've attached the complaint history of the matter. It was October 28th of 2010. There was a legal reviewed it. He didn't find any incompetency in any of the materials, so got him a plat. That's what we did. So he obtained that. February 3rd, this case was deferred until the October 2010 meeting because of the insufficient material. Mr. Hagel reviewed it now that he had the plat. And then he found that the respondent was accused of failing to communicate with the complainant, an adjoining landowner of a parcel. parcel for which there was no evidence of such. The respondent provided an affidavit that not only did he communicate with the complainant, he traveled the property with him and discussed any potential disputes, offered his professional judgment, and the complainant never had his own property surveyed. Conduct. So that brings us to the next one, February of last year. In this case, it's the same thing, was referred to a board member for review because of the allegation of incompetence. This particular situation had been considered by the board before and resulted in dismissal, but the complaint information was forwarded to a board member. In case there was anything new, Hagel again reviewed that one. And the facts as presented in this complaint are identical to the previous dismissed complaint, so February 2nd meeting of last year, the board voted to dismiss the matter with prejudice. Because no legal action has been undertaken, we will not discuss the disposition of this case any further in the public interest of providing final decisions for controversies before it. Because no legal action has been undertaken to settle a boundary dispute with an outcome unfavorable to the respondent, not enough evidence that the public health, safety, or welfare has been injured by the respondent's professional actions. So the recommendation actually is just to affirm the board's previous decision, which was to dismiss with prejudice. Hearing it over and over, and the policy reason is so we can bring an end to this particular matter. Public interest means something that has to end eventually. So that's what this is about.
Either your review, or did a board reviewer look at it, or just you look at it?
I looked at it and compared it to the previous files, and I spoke to
basically seeing nothing new.
Have to be new work product and
right.
Stuff, and there's
same players, same game, same discussion, basically.
No other action's been taken. No lawsuits to settle boundaries. Just something that we could look activity to make a decision. So
Frivolous lawsuit.
well, it's certainly becoming that way with I think that if this person feels he's been injured by the surveyor, the next step is to can't find any misconduct. Even if somebody doesn't agree with it, that doesn't mean it's wrong. It can even be different from a previous survey.
Yeah.
So
Second, all those in favor? Opposed, likewise?
(2013-005661). The complaint alleges the respondent, who's a licensed surveyor, committed misconduct, providing surveying services. A review of the complaint information shows that the complainant is an adjoining landowner who agrees with the respondent's plat. There's no evidence in the file that the respondent's plat was anything other than a professional opinion that did not establish property boundaries. And in a letter, the respondent advised the complainant that he should have a survey made for him by another surveyor, since the respondent was hired to produce the survey by another entity for its property. And there's no complaint history. A lot of words to describe a boundary dispute. which we don't really have jurisdiction.
Wording of that middle sentence there, Rob, it says there's no evidence in the file that the respondent's plat was anything other than a professional opinion that did not establish.
Somebody took his plat and filed it, and it became the boundary. He
Wasn't
just
recorded?
produced it.
But
Not recorded.
But is a boundary plat.
Yeah, it was a plat of the adjoining property to the complainant, but it was never filed, so it never established anything. So the adjoining landowner disagreed with the way it was laid out, but unless it's filed, it's just an opinion.
That's basically what all of our work is an opinion.
It becomes a legal document when it's filed and establishes a boundary. And it hadn't got to that point yet. That's why the respondent said you should get the surveyor to do your property,
Certainly, that's a very...
which I think was responsible before anything gets filed.
That's very commonplace in my practice. If we survey John Doe's property and the neighbor, Jane Q. Public, comes over and says, we don't like your survey, we don't agree, it's a very common thing to do two things. One, ask her why she doesn't agree, and then two, encourage her to employ another surveyor to check it, yeah. And maybe in that process, if the other surveyor determines something that's different than what we did, maybe we can confer and, come up with a conclusion as to where it should. Don't concur, maybe it has to go to court or whatever. But anyway, that's pretty well a routine process in my mind.
And I see the same thing. The only thing that I might take in, I don't think that it's necessary that a plat be recorded for it to be a legal document, because if I put my stamp on there.
Well, I meant for the purpose of establishing a boundary. It's certainly a legal document.
Yeah.
But now, in the same regard, I think I know where Galen's going. If an attorney who writes legal descriptions more often than not takes that plat and crafts a legal description for the transfer of the property, then in effect the plat is a legal document, even though it is not either attached to the deed or recorded separately in the courthouse, in my opinion.
Yeah, I agree.
None of it's gotten that far in this case. Nothing's. And that's why I believe this guy said you need to get your own.
Hey, if you don't agree with my survey, you have the right to surveyor and refute what I have done.
I didn't find any. Once again, I recommend close just in case. If something develops later, we will have something to review.
Other questions? If not, Chair will entertain a motion.
So moved.
Okay.
I'll second it.
Okay, we have a motion to accept Mr. Herndon's recommendation in this matter. All those in favor?
Aye.
Opposed? Okay, Rob, just a question of information. Since we've now closed our legal cases for the moment, until you get back to the office and open the mail, I guess.
Yep.
Where are we relative to any formal, informal? Are we caught up on those also? Okay.
Have any consent orders or settlement agreements out that will expire? When they expire, they would go to litigation, but we don't even have that. So, and we didn't generate any just now. So, but tomorrow we'll get 50 of them. It's spring. It's time to start, getting out and doing things. So who knows?
I guess we just improved our status as a board with the department of our efficiency in handling our complaints. Seeing as we were more efficient, we'd have to be the most now since we're at 100%.
Well, enjoy it for a while it lasts.
Yes.
Now we can turn our attention to rulemaking.
Okay. Thank you very much, Rob. Appreciate you. Okay, I think we will take a 5-minute break, and when we come back, we'll start talking about our board policies, if that's all right with the members.
All right with me.
Okay. Okay, it's now 10:09. We'll reconvene. Next item on the agenda is to update board policies. This item will probably take just a little while. We have 19 policies. The 19th policy we just recently crafted, so that one shouldn't take very long to review. But the purpose of this is to go through these policy by policy and determine whether or not they are still applicable, whether or not they need to be modified or just simply deleted. So started, and like I say, this may take a little while, but I think this is something that we need to do, because the ultimate result of this action by our board should, in my mind, result in these policies being posted on our website, so that the licensees can see things that the board has reviewed and what the board's interpretation as far as a policy is relative to these items, because these are supplementary explanations of, in many cases, either rules or statutes that are very important to our licensees, and they need to be familiar with them just as we are. So that is our purpose. So we will start with board policy number 1. You have it. You may have it in writing, and you may also have it on your iPad or whatever. So number 1. Tennessee Board of Examiners for Land Surveyors will be enforcing a policy whereby an individual submitting an application for consideration by the Board of Licensure for licensure, if after 2 years from the original date of application the individual has not passed the required testing, that he/she must request and submit a complete new application. I think that's what we discuss each and every time that we review our applications. And I wanted to me, I think that one's in order. However, board policy number 6 tends to address the same exact issue, I believe. So I want to skip to 6 and go over it at the same time, so we can decide if we still need both of them or what we need to do. Tennessee Board of Land Examiners for Land Surveyors is revised, and we'll be adhering to the following policy. And I think what we're doing was referring to policy number 1, that they were revising it, but they never did delete it. I think that's what's happened.
I think so.
But it says policy statement dated January 1, 1999, which none of these statements we have before us have a date tied to them. Revised effective October 1, 2005. Effective October 1, 2005, any individual submitting an application for consideration by the board for licensure, if after 2 years from original date the application of the individual has not passed the required testing, must wait 1 year before submitting another new and complete application and application fee. The board may require documentation of additional experience and or continuing education. I think that it would be good to eliminate number 1, policy number 1, and modify policy number 6, striking the sentence that says policy statement dated January 1, 1999 and revised effective October 1, 2005.
I agree.
Unless, and I'll ask Nicole since she is here and Donna is not currently, unless it's necessary for us just to eliminate all dates and then just attach today's date of the actual review of the policy if we need to do that. That's the only question I would have.
I don't think the dates are necessary. policies can't be more restrictive. It can just interpret. So if additionally restrict a licensee, it needs to come from a rule.
I understand where you're coming from. I'm just simply saying that if we go through these and review them, revise them, approve them today, and then we have them actually posted on our website, they may have been existing, may have been effective for a long time. However, tomorrow, for example, if they were posted tomorrow, would be the first time that the registrants would be per se made aware of them, even though some of these have actually been mailed out in letter form to the registrants.
Yeah.
So I can go either way on the date issue. I don't have a lot of problem with that.
Board. And they say, well, how long? And they say, as of this date, but the only thing we revised was whatever we wanted to put on there.
After 2 years from the original date of the application, the individual has not passed.
Looking in our laws right now, there's a statement in there someplace, Rob, about the where an individual takes it. They can only take it so many times. Here it is. 6218.111 stipulates that there are prerequisites for a third examination. And that is entwined with this particular policy from the board.
That's right in here pursuant to.
Right, that's fine. I have no issue with that. That's what I want to do. I want to get these cleaned up so that not only do our registrants understand them, but they are directly tied to our statute, so that there's not really a question of what we're trying to tell them. Right. Yeah, we just didn't decide today that the sky is orange. Technically speaking, this policy is more generous or more lenient than what 6218.111B says.
That's correct, it is.
This policy has been what the board has went by for many, many years in lieu of 6218.111. So, if we eliminate the policy, then we should strictly adhere to 6218.111. So the question posed now is, do we strictly adhere to the statute, or do we stay with the policy?
Policy can restate the statute, but policies don't have any.
Five that we're discussing these policies, right off on the very first one.
Whoever drafted these policies, I wish they had referred to the authority that they're using.
Why we want to look at it. So basically, what I'm hearing from you, Rob, is that you would like us to eliminate policy 1 and 6 in their entirety, and then the board simply go by 6218-111. You agree? I mean, I have no problem with that. That's why we're doing this. How about you, Gail?
I don't know that I have a problem with it. The item number 6, it's stating here that he must submit. I think it was a year time limit on that thing, wasn't it? Has not passed the requesting must wait 1 year before submitting, whereas demonstrate to the board's satisfaction that he has diligently studied the subject. Fails the exam, the second exam, and the results of his previous exam, because we would not meet with him until following after our meeting. So it'll be a year's time probably. Policy was put into place.
My concern here at this point in time is CBT, because we're going to be discussing that here after a while. My question to Rob would be, do you think that 6218-111 applies to all examinations that the board is responsible for to effective licensees? Or is it only the board-specific portion?
It doesn't specify. I would say all exams, all 3 of them. And we have a rule on exams.
Doesn't address that. That's why I had to go to the other location to get that.
So if we did make a rule that addressed this,
We're going to be crafting, that's, after a while, we're going to be talking about CBT, and that's part of the craft that we need to do, is make sure that we have these statutes relative to CBT so that we're in order when that begins, because we have several issues to discuss about that. So, having said that, Galen, do you think, are you comfortable with eliminating 1 and 6?
Oh yeah, I'm comfortable with doing that. And there again, let's go back and address CBT just for a second. Oh, that we're going to address this later on, but with CBT, the applicant can take the test more than once in a year's time, because there are 4 windows that are open twice, and then he has failed it. Then the cutoff is, according to statute, he has to come before us before he is allowed to take it again. Mm-hmm. Now then the question that will come up, I guess, and what about the exam fee? Because, see, if he has to reapply to take the fundamentals of surveying, then what's that going to do? I think that's going to have to be addressed too. And so
the test is going to be computer based.
Yes, that's correct.
The PS is not.
At this moment, yes.
And the Tennessee specific is not.
Right.
talking about this very thing and what it's going to do to us beginning January 1 of next year.
Well, now let's clarify. The examination fee will go to NCWES, whereas before we were charging an examination fee, which their fee is double what we were charging now on the CBT, but the application fee, the $25 application fee, still comes back to this board.
So will the fee to take the PS?
Yeah. And actually, you know, I'm on the EPS committee, and that's one thing that we have basically been discussing, and it's further along because within the first 2 windows of CBT for FS, it will give the NCWS the criteria that they need, the structure, to tell them what rolls over for the PS. Because, for example, I'm going next month to be cursor for that meeting is to set up the CBT version of the PS. So, you know,
Farther along than the PE. That's for sure.
much further along. much further along. They
Because
really are.
2015 is less than 2 years.
Yeah. But the what they're saying is the learning curve that they went through with FS has now given them the foundation, short of actually giving the examination, to basically attach the PS to it so that once the examination is given, they can see the hurdles and the pitfalls there, modify, and be ready to go PS. I think it's late 2015, not early, but I'll know better when I go to the meeting in Clemson. But, yeah, with the FS coming online, the PS is truly not very far behind.
Up for a brief time, not having a contract at all. That goes away eventually.
Right.
So we're just going to have a contract on.
And we're probably, the way our board functions and so forth, I think we're probably 5 to 6 years out before our exam could go board given at the board office.
Okay, you're talking about the state specific.
State specific,
Yeah, I agree.
So, in other words, the whole thing is gravitating towards the, you know, availability for the applicant. But anyway, we're digressing. So, are we in agreement that item 1 or policy 1 and policy 6 needs to be deleted?
Itself for the review with the board and everything would take.
I'm gonna yield to Rob's interpretation that if we stick with the statute, we'll just go that way.
I think so.
Because I mean that's the way that I've tried to do things since I've been on the board, by the statute, and that's why we're now getting a chance to get back to it. So,
I like.
well, let's just go ahead and have a motion to eliminate 1 and 6, and that way we'll get those taken care of right now, and then we'll move on.
All right, I'll make the motion that we board policy with number 1 and policy number 6 and adhere to the statute.
Motion is second. Any further discussion? If not, all those in favor?
Aye.
Opposed? Okay. 1 and 6 are now eliminated. Okay, policy number 2. When NCWES Fundamentals of Land Surveying, at that time called the FLS, they later changed it to the FS, examination scores are reported, the board office administrative staff may, at their discretion, release the scores to individuals not receiving licensure, which means the ones that fail, thereby allowing individuals extra time to study the remainder of NCAAS Principles and Practice, PLS at that time, it's now PS, examination, and the Tennessee Specifics, TLS, we call it TS, examination. It's my opinion that when we allowed our office staff to forward to NCAAS, that NCAAS could release the scores, that we no longer need this policy. So basically, if I take the examination tomorrow, as soon as the scores become available, this board has allowed NCAAS to just go ahead and release the score to me so I know whether I pass or fail. That's all they tell me anyway, is pass or fail. And if I fail, they send me a little chart to show me where my weaknesses were in certain areas to help me study. That's all it really amounts to, because what we were seeing, we just didn't feel like that it was necessary to delay an examinee from having their results, because what was happening was, if the exam was taken at the end of October, the results were coming back second week of December. The board was not meeting until the second week of January at that time. Now we don't even meet till February. So the examinee would not be getting their results until the board met and approved them. Well, there was nothing for us to approve because we didn't write the exam when we didn't score the exam, so we felt like it was appropriate just to go ahead and let them have it. So on the heels of that, the chair will entertain a motion to delete number 2.
Let me ask a question before we do that, Tim.
Okay.
When they say release the scores, they're really not releasing the scores. They're just releasing the pass or fail.
Right.
That's all they're doing.
Yeah.
And
they did prior to, let's see, we're in 13. Prior to 2010, they did release the scores. You actually got an official score, a numeric score.
Okay.
And then NCAAS changed their policy and just simply said, now pass or fail.
Okay. Frankly, I don't see any reason to retain the policy.
Okay.
I mean, if that's well, maybe I should ask this: the policy. And if a Anna and ask about the score, does she have the score, or do they call NCAAS directly and get it?
What happens with that, Galen, is in the paperwork, as I understand it, and if Donna was here, she could clarify it, but they give the board the option of release scores when they have them, or release the pass-fail when they have them, or sending the pass-fail to the board for board release. Okay? Either way, if we, the board, allow them to release pass-fail to the examinee, the list is still sent to the board so that the board is aware that John Doe passed and Jane Doe failed or whatever, because that has to be part of the records that Donna has. But the difference in those two windows, may be a few days or a week or two even. But that's not detrimental to our board function. So she does find out just a few days later.
Alter their policy, then we don't have to hit a moving target. If they decide to release the exam scores today, or January 1st, have that cut score undoubtedly, and whether they pass or fail it, it'll have that information available to them maybe, or and just give them pass fail, and then you don't have to have a policy on it, and we don't have to change moving target.
NCAAS determined that the score for the examination really meant nothing other than you know, you took it, I took it, and you made whatever, and I made whatever, and you did better than I did whatever. I mean, you know, that's the only thing that was accomplished. It wasn't accomplishing anything. It didn't change status, didn't help you take the professional exam faster, none of those things. So that's why they went to pass-fail.
I understand. I helped with a national exam, and I understand the cut score thing, and I understand, and it's complicated to explain it to the licensees, and you know, pass fail, and you could sit right next to the same person and take two entirely different tests on a database. And I don't envy your task of going there and working on the cut score. That's but this way, I don't think the board has to create a policy for this particular thing and expose it to the light.
Yes, I think the only thing is that if we don't have something that is in-house that says I, as a board, can release to you, the applicant, then we wouldn't release scores. But do we have anything that states that we could? Or
First off, we don't get the scores.
yes, but I'm just saying that we get the information from NCAAS
Yeah.
stating where they passed or failed and their weaknesses. Do we not get the same thing that they have?
No, Donna would only get a list of who passed or failed.
But not the weakness areas
We
of
don't get
weakness.
the weakness areas. That goes directly to the examinee.
Okay.
NCAAS provides it. Now, before we decided to allow NCAAS to release those to the examinee, Donna was getting those and she was forwarding those. So we were actually just adding a middleman step that we didn't really need.
Okay.
So, yes, the examinee gets all the information they need, particularly if they fail. And of course, they still get the pass if they pass. And that's all they get is you have passed and you need. And basically what their letter says, it's a form letter from NCAAS. It says you have passed the FS examination and you need to contact your local jurisdiction, because it's a form letter for the whole United States, relative to the next step in your process for licensure in that jurisdiction. It's very generic. So
That's okay.
Yeah.
Well, in that case, then I see no reason to have a policy number 2 then, and I agree with you. So,
okay. So we need a
motion that we dispose of, get rid of board policy number 2.
Okay. Favor? Opposed? Okay. Okay, now we're on number 3. Effective October 23, 2003, the Tennessee State Board of Examiners for Land Surveyors will vote at each board meeting as to whether any or all portions of the board meeting, depending upon content, will be allowed for professional development hours. Now, I want to go on and read number 4 because I think it's part of the same thing. The Land Surveyor Board members, at their discretion and by vote only, may receive continuing education credits for attending board meeting. The hours awarded will depend on the agenda, formal hearings, informal conferences, etc. A vote will be taken at each board meeting for the number of hours to be awarded, and there may be some meetings where no hours are awarded. The hours awarded will be reflected in the minutes of the meeting. The first thing I want to say is I understand what they're saying. They're a little convoluted, and we probably need to work on wording them here just a little bit. Secondly, there is no question in my mind that the work that the members of this board do should be professional development hours for this work.
Putting that into
Yes.
this stuff needs to go away because this we'll do it shortly at this meeting. We can move this stuff into under our continuing education rules.
Well, that's, and I think you've got the right spirit there, Rob, is that in our continuing education rules that we're working on, that chapter, I think it is part of that intent, because we discussed it before, that sport activities be able to have some type.
Let me suggest this, and until that is made rule, that we probably ought to retain this policy at least for the interim period until that rule takes effect.
Well, we wouldn't be relying. Because it meets these criteria.
I think in the spirit of where Galen was going, I think that if we're going to utilize the
Policy pursuant to. Policies explaining how we're applying the rule.
yes.
It's fine, and maybe, I mean, a policy as to how it is applied, maybe just because it says that, how it's applied, maybe the policy is the thing to impart this to whomever is.
Yeah, the only issue that I had with the way the policy was crafted was it seems to be a voted on and then be reflected in the minutes, which I have no issue at all with that, but I think it's sometimes hard for us to say that on today, at the start of the meeting, we'll make a motion and vote on this matter, and that we're going to have 5 continuing education credits today. It's hard to say that, when something comes up and we meet 10.5 hours or something.
I think that rather than to state it at the beginning, we probably ought to say, all right, we've had this many hours at but then we had 13 hours of what.
I would prefer to do that. I would prefer to at the end of the meeting, as we conclude, simply discuss it for a few moments and say, how long were we here conducting business, and what is the board's pleasure relative to continuing education. And we do that. We put that in the minutes. That's it.
I think you'd be justified. For all the preparation time, I think it'd be fair to let you have the time you're physically here.
But could we do this, Rob? Let me just throw out. Let's keep policy 3 and strike the date, and then simply at the after it says professional development hours, add pursuant to 0820-5-.05 2.
Let's put it at the front, take
Okay.
the effective date, and then instead say pursuant,
Okay, sure.
and then the comma, and then
Okay.
we really just wondering if we need.
Well, that was kind of where I was going initially. I have no problem keeping 3 as it is. Eliminate the date, putting pursuant to, or doing some kind of merging between them. But so what you're saying is at the end, then we should say 4 licensees or for registrants on 3.
Well, 4 says the land surveyor members, and the licensees are. I am interpreting 3 and 4.
Sure. No problem with that.
They're different.
Oh, we don't need that because they're licensees too.
Potentially, item 3, there could be potential
Version around.
audience.
Yes.
Today there is not.
Right. Okay. I don't
And of
problem
course
with that.
the
I don't
board-
problem
Right.
with that. I don't problem with that.
I'm just saying that's one reason they may be different. Within the dates.
I will say that I think that each one of those should state the rules on or -5.05. Each policy, 3 and 4, ought to have both of that in each one of them. Because
It goes away. Yeah, that's fine. I have no problem with leaving them both as they are, striking the date and put pursuant to in front of both of them, if that's what everybody. Modify 3 a little bit and add, registrant and board. We are a registrant, even though we're on the board. Sure. We want to leave both policy 3 and 4. On policy 3, we're going to strike the date, effective the date, and put pursuant to the 0820 in front of number 4. Now we're going to hold just a moment. Miss Sue had to step out, so we can't vote until she comes back. So. I think number 5 applies to 6218-110 on reciprocity. And the way that statute reads to me is that it's up to the board to determine if the qualifications of that individual from another jurisdiction are qualifications, and if it does not, we can require them to take examination.
The applicant will be required. That takes away your discretion.
Look at 6218-110 there, Rob, first. Vibrated.
Kind of talked about this with the 10-year rule.
Right.
When somebody came in with an inferior, for lack of a better word, an
Right.
inferior license, felt they'd have to do something more to come up to our minimum standards.
In here because it's a policy, and then everybody should know where the policy comes from. It comes from the board. Voted on. Okay, Ms. Sue's back with us. We're at a point, Ms. Sue, to have a motion, policy number 3 and policy number 4.
Policy number 3, I move that we strike the date and add pursuant to statutes at 820-5. -5.05, and then take the rest of the
Robert's Rules of Order, since we're adding the same language. Have a motion on the floor. All those in favor? Aye. Opposed? Okay. We're going to keep policy 3 and 4. Okay. Now, Ms. Sue, while you were gone, we started discussing policy number 5. And currently, we've agreed to strike effective to January 2005. The board voted that. that's where we're currently at, and we're looking for statute to basically support this. We've discussed 6218-110, which is reciprocity. Attorney heavily right now. In my mind, Rob, I think that we could stipulate that one and also the one prior to it, 6218-109, because over in 2C at the end of it, that goes back to our 10-year scenario. I think that those two statutes would fall in order with this particular policy. Policy then just being a clarification of those two statutes. Not aware of that. And well, there, you've got a situation to where, as we discussed at our Surveyors forum, multiple scenarios for licensure. You have experience plus some education, you have strictly education, you have other combinations, and because we are so unique about how we get to licensing our profession versus, for example, the engineering profession, which they're more structured, 1, 2, 3. Reciprocity in their world is a much simpler process.
Yeah, the laws of nature don't change much from state to state, but in property, every little inch of land is unique. So I'm not disagreeing with you that they need to take it because Tennessee is the only Tennessee laws here.
But again, in support of that policy, I would use 6218-109 and 110.
One thing y'all done is consistently apply it, because I don't ever remember ever.
Whatever statute you agree to, that's what we're going to put in the front of this. Yes, ma'am. Sure, no problem. Okay, all right. Okay, we will table number 5. We have already deleted number 6. We will move on to number 7. As of January 3, 2006, to stop approving or disapproving educational courses, the board will not tell applicants how many hours of credits that they have or don't have, and that they will be furnished with a list of types of courses is requiring and is acceptable to the board, and that specific courses henceforth will not be approved, disapproved prior to the board making the application. The board will respond to general questions pertaining to the education in the event of a potential applicant doesn't quite understand the board policy that the board is submitting to them, and they are invited to send the board general questions about education, but the board is not going to sit down and pre-approve or not approve a transcript. I call this the Lance Lingerfelt policy.
What does that mean?
What it means is, and Lance, by the way, is my son, and this happened after the board approved a request. What it amounts to is the board at that time no longer desired for little Johnny or little Susie to send in a list of courses that was at 123 University relative to surveying, and little Johnny or little Susie wanted the board to say, yep, we're going to approve those courses whenever you take them and you make an A or B in them. And that's basically what it's saying. What was happening at that time, and I refer to my son simply because I remember when he sent a question to the board, he wanted to take some courses, online courses from the University of Wyoming, who has a surveying certificate, which is their investment in taking those courses. He wanted the board to say, yeah, we'll take those if you take them and you pass them. And at that meeting, the board said, yes, you can take those courses and pass them. And immediately following their response to my son, they crafted this policy at the same meeting and said, hey, look, this is going to become too cumbersome for every future registrant that doesn't go through, for example, ETSU's BS program or whatever, to ask us about every college, university that might teach a surveying course somewhere in the United States. So we just don't want to fool with it no more. We'll give you general information. We'll publish what we publish, but otherwise, submit it. We'll review it at the appropriate time, appropriate location, and if we don't have enough data, we'll ask for it. And that's really all that's asking for. And it was more of a hey, all you people that's applying, stop sending us questions about your education. Just send your education in, we'll review it. That's kind of what all it means. So whether or not we need to keep it or not.
You can keep it. That's actually not. You're not the only board that has that problem.
Yeah.
And it's not just technical trades. What do I need to take to?
I think that in my mind, on this one, we strike as of January 3, 2006. Go back to 62.18.109, which gives us the criteria that applicant should apply by, and then we can actually leave this policy if you want to do that. I certainly think, to me, that's very appropriate.
I think it is too.
Just as if nothing else, to just say, hey, look, we got a policy. It just says, we're here to work. Don't bother us with frivolous things.
So you have a.
Comfortable with that, Mr. Herndon? That we add the language pursuant to 62.18.109, the board will, and strike as of January 3, 2006, 2. Strike. Okay. Do we have a motion to that effect?
So move.
I second.
And we have a second. All in favor? Okay. Okay. Welcome back to Miss Mulder. Congratulations on you receiving an award for 25 years of service to the state of Tennessee. Where we are at, Donna, currently we're reviewing our policy statements. Policy statement that I think we'd like to seek a little direction from you. We're currently on policy statement number 5. I'll give you a moment to find that.
Just review what we've done so far. I think we've deleted number
6 are gone now. Caught up a little bit there, Miss Donna?
I think so.
Okay. We're on policy number 5. I think the question bodes on number 5. We're justifying it by statute, and the question to you, I think, and Nicole, in your past board experience, board providing out-of-state individuals with a license based on giving them a license without them having to take a test? Okay. That was my understanding, but we wanted to kind of make sure from you because you have more experience here than any of us.
As long as I've been here, they've always had to take the test.
That's fine.
Yeah, sometimes there's a translation between.
So
Or the vote was
are you
taken.
comfortable then, Rob, adding the pursuant to 6218-109 and 6218-110? Or would you feel better not adding 110? One reciprocity. Have a motion to that effect.
So moved.
Second?
I'll second.
Motion is second to add pursuant to 6218-109 and 6218-110 and striking effective date January 2005. The board voted that. So we're going to strike that. So we have a motion and a second. All those in favor?
Aye.
Opposed? Okay, we will keep policy number 5. Now we move on. We're now at policy number 8. Effective January 25th, 2007, the Tennessee Board of Examiners for Land Surveyors will be adhering to the following policy. Due to the conflict in Iraq and Afghanistan and extended military service, several surveyors have requested the continuing education units be waived for renewal of their Tennessee Land Surveyor's license while on active duty. Out of respect for their dedication to the United States of America, we, the Board, hereby make this policy that the continuing education units will be waived for our brave men and women serving out of the country while on active military duty. The licensees must supply proper documentation to support their request. That's actually a rule. That's correct.
Let's delete that.
I think that one needs to be just deleted straight up because we certainly make all provisions for active military.
120 consecutive days.
Right. Yeah, that was kind of a may have just been I think that was one of those at the time things. Everybody was doing it, and they was doing their patriotic duty, which we certainly respect that. Okay, we have do we have a motion on this number 8?
So moved.
Okay, we've got a motion to delete it. We have a second.
Second.
I have a motion and a second. All those in favor?
Aye.
All those opposed? All righty. Okay, number 9. Effective June 14, 2007, when a registrant has a license or certificate of registration to practice land surveying, I think it should say in another jurisdiction, revoked, suspended, or voluntarily surrendered as a result of disciplinary proceedings, the registrant may be subject to disciplinary action before the Tennessee Board of Examiners of Land Surveyors. If the other jurisdiction imposes discipline less than the action stated above, the registrant will be routinely issued a letter of caution by board staff. The purpose of the caution letter is to advise the registrant that the board has been notified of the disciplinary action and puts the registrant on notice to avoid similar infraction in Tennessee. Now, I want to say one thing about this. NCWS has a law enforcement exchange. It's one of the services that is provided with our membership with NCWS. And each and every complaint that we close and that are completed and are the same complaints that we report in our newsletter because they have been complied with and are completed. I hope that those, and Donna, you have to tell me that, I hope that those are all being sent to the exchange, the purpose being so that if that particular person who has been penalized by our board is licensed in other states, those other states will know what we did. And in token, I hope that you watch or monitor, or they tell you the same thing from the other states.
Yeah, I know. Everyone had disciplinary action. Not with the interim.
Well, the one I was concerned about mostly is if, for example, if there's a registrant in Kentucky that some of this action happens to, a suspension or whatever it is, that we know about it and then it's able to be brought to our board because that individual is also one of our registrants so that we can address it, even though whatever he didn't do inside Tennessee,
Right.
but he did it in another jurisdiction, and we may need to look at that to have some sort of action.
That's actually a duplicate of what England. In our statute. Less than a revocation or suspension, they issue that letter.
Yeah.
I just want to make sure that we're on board with that.
Statutory authority.
I think that
And the rule is misconduct.
in the rules, Rob.
0820-04-
So So where we stand then, Rob, as a recap, we want to strike the word effective June 14, 2007. We want to add pursuant to 6218-116 and 0820-4-.07, parenthesis 3, parenthesis B.
Statute at 6218-116A1F.
Seven 3B, yeah. And also in the second sentence of that, we want to change where it says practice land surveying and another, it should say in another. Correct? That'd be better, a little bit better English. In another jurisdiction. That's the way we stated in ours. It says in another jurisdiction. Okay. Any other discussion? Yes, ma'am. Just basically, it's legally putting the arms around all possible things that we can do in a complaint scenario, whereas the rule only really addresses revocation, suspension, or voluntary surrender. So in other words, it's the old, what I call the old number 9, any and everything else.
I guess.
Basically let the licensee know that, hey, look, if Kentucky smacks your hand,
We could.
we're paying attention, and we're probably going to smack your hand too. Maybe. I think we're good with that.
That's how NCAAS helps regulate.
Okay.
That's
hurt. It
I
just
think that's
didn't-
the intent,
Right.
is to keep them from screwing up in this jurisdiction.
Well,
Hey,
in our profession in engineering, you're basically naked with everything you do. Everybody sees.
Well, I'll give you an example. There was a surveyor that had his license revoked in Kentucky, and he was licensed in Tennessee, and Tennessee did not revoke his license. He then did something in Tennessee that caused his license revoked in Tennessee, whereas had this been operating properly, it would have been revoked probably immediately in Tennessee, and then he wouldn't have harmed the public for a period of time before Tennessee could wrap their arms around it and actually take the license. So that happened several years back.
Letter of caution is something we decided to do something without having
Worse, if it's something where they were licenses impacted, it would become a complaint.
Because I think the last sentence of the policy clearly states that. I think it's, yeah. Okay, I think we're ready for a motion on this. I think what we're going to look at is adding the pursuant to the particular statute and rule that we have cited, and we're going to strike effective June 14, 2007. and we're going to change the second sentence, the word an, A-N, to I-N. So I think we're...
Second it.
Okay, we have a motion and a second. All those in favor?
Aye.
Opposed? Okay. Okay. Now we come to a policy that's very appropriate. It may need to have a date. We're on number 10. It says on February 9, 2004, the Attorney General, Paul G. Summers, gave an opinion which seems to violate state law. Late in 2006, this opinion was placed in the laws and regulations for surveyors. The opinion is as follows. A city in the exercise of its land planning authority is not bound by the minimum standards governing the practice of land surveying and engineering. Therefore, a city may require an engineer to perform functions that arguably may be performed by a land surveyor. While we are in agreement that a city or a county government agent may not be bound by the minimum standards governing the practice of land surveying, this board does feel that they do not have to abide by Tennessee statutes. They do have to abide, I'm sorry, I don't know where I got not. This board does have authority over the unlicensed practice of land surveying. Please see the following, and it states 62-18-120. Goes further to say, board policy, there is a huge difference between state law and minimum standards. It is true only surveyors fall under the minimum standards. However, no person or government agency may appoint or require any individual to a position, project, or function that violates the law. Therefore, the board must follow state law. Any person practicing land surveying who is not duly licensed to practice is in violation of 62-18-120, public welfare requiring it. I think that one's pretty straight up. It says what it says.
I think you could probably just ignore it.
Law is what governs.
It doesn't seem to be a policy.
Now, this is one of our, and you've heard me speak about it before in this venue, is that our profession is regulated by too many other entities. I've never been fond of that.
This opinion was placed in the law.
I didn't know where that was.
I don't either.
Law and regulations is our statutes and administrative rules. If it's not in there, it's not the law. Number 10.
Oh, I didn't know where to find that one. I did a little looking, but I did not come up with where to find that one. Did you do any good with that one?
I just believe.
Criticized and not effective, so I don't, rather than try to track that one, I think we just need to get rid of it.
Track it and what have you, and I think the statute takes precedent over whatever may have been stated by.
It seems that the board at that time apparently was just reinforcing 62-18-120. I didn't see any real great necessity to do that, other than they just wanted to speak to that Attorney General's opinion, which is much.
Had a couple of rulemaking hearings since then, and
Have a motion to delete this. Second?
Second it.
Okay, we have a motion second. All those in favor?
Aye.
Opposed? Okay, we move on now to number 11. Number 11 is pretty wordy. I don't know if I want to read all of it or not, but we'll read as much as we can. Across the state, within various city and county government bodies, there are many differences between the way subdivision submittals work through planning authorities. This inconsistency has caused many problems with persons other than surveyors making these submittals. Then it simply gives the definition 62-18-1023 of what surveying is. And further goes on to state, accordingly, the platting and layout of lands and subdivision thereof is clearly the responsibility of the surveyor, which we all understand that because that's in our definition. Therefore, the board requires that all plats or layout of lands and subdivisions shall bear the seal, date, and signature of the surveyor. This includes, but is not limited to, preliminary and final plats submitted to planning commissions prior to construction. Also, in compliance with previous board policy, the surveyor's seal, date, signature shall be included on all record and as-built drawings, public welfare requiring it. It's to my recollection when we changed our standards of practice in 2009 that we included this.
Yeah, I don't see any point.
I think that at that point in time, we actually added the language of that a surveyor needed to stamp and mark preliminary and so forth for the documents. I don't have that in my hand right now.
Probably obsolete, like you said.
I think that is obsolete. Discussion about it.
Oh, this is dealing with planning commission, but what do we do in a case of soil scientists and what TDEC is insisting that they do what they call a sketch plat, and they sent that to their offices, the health departments, and what have you, and they are putting survey information on this document. The soil scientist himself is doing this, and in effect, he is surveying to create this document. So where do we fall? Would that fall under this particular thing, or are we covered with the change that we did in 2009? Right.
Like a geologist, they're locating things under the ground and writing reports. I think, and I don't remember when that became effective, but it was fairly recently. Yeah. All scientists are now licensed professionals in their own right. So whatever they do, they have to put their seal on it. They have a license, but the seal.
And I'm not opposed to them, preparing the plats that they have to prepare, because I realize what the intent of that is. The only thing is that there are counties that require that the surveyor locate these things on these maps. Williamson County in particular, doesn't matter what it is, they won't let the soil scientists locate it. They say it has to be located by a surveyor. However, the intent of TDEC was, with this particular statement or policy that they have, was that in rural counties where there may not be a surveyor or they're few and far between, the soil scientist goes out and he tests the soil, finds the points, he gets his handheld GPS and he does whatever he needs to do, and he locates those on the sketch plat based on property boundaries and what have you, which I just finished one that a soil scientist did that very thing, and he stated, I want the surveyors to locate it. Well, he located it, and then he told me where it was, so when I went out, it was exactly where he said it was. So
I think it's a matter of intention of why you're doing the kind of work you're doing. He's not doing it to establish property rights or boundaries. He's trying to just find. Rights is he needs you to come out and actually locate it for the purpose of rights to it and all that.
And that's fine, I understand that. But where he did that, there are soil scientists that won't do that, because TDEC gives them the authority to do this particular thing. Might do that because the first meeting that the Soil Scientist Board had about it, and we chose not to state anything other than the fact this is what the definition of surveying is based on our statutes and rules, and I gave them the definition of surveying. And I said, if you are doing this, any part of this definition, then you're surveying. And if you're surveying and you don't have a license to survey, we'll be glad to give you a license if you take the test. But that's as far as I went with it. Not sure what the practice is right now.
I could probably tell you what soil science is. Let me see if I can find it.
Okay. Because it might be worth taking a look at that. I know in reason that most of the soil scientists, in particular in the Middle Tennessee area, starting in Davidson, Fellwalk, who is with the health department, John Gibby, Dickerson in Rutherford County, Philip Dickerson, they prefer to have surveyors locate the things that they need to have located, so that it. Yes, I think they should. But TDEC is giving them the authority, the soil scientists, to go out and locate things that surveyors probably ought to locate and show on plats.
I can tell you what soil science is by definition. Soil science services include the investigation, inspection, collection, or evaluation of soil as a means to classify soil pursuant to the use and application of the USDA Soil Taxonomy Standard as revised, or the interpretation, inventory, planning, or mapping resulting from classifying soils. And that's where the definition leaves off. So I guess that's a little, the mapping part must be, but surely they're astute enough to know that if you're really going to do surveying work, you need a surveyor to do it. There's a certain amount of mapping I guess they have to do to locate where certain types of soils are. But they don't need to start producing plats, that's for sure, of what the area looks like.
Well, I think that's what TDEC wants them to do, is to do what they call a sketch plat.
I'll talk to TDEC about that, see what the story is.
In on this thing, I know that the soil scientists that were there, and I had one other surveyor that was with me, but we were in agreement. Soil scientists in Middle Tennessee said that, hey, if it's locating a soil site on property, you, the surveyor, are the ones that's supposed to locate it, not us.
They already knew where it was.
Yeah. And
Already located.
TDEC says you have to tie it to a property corner or boundary. Well, TDEC is right, they have to do that, but apparently the soil scientists are being allowed to do that with these sketch plats. So,
While we're at it, I can tell you what geologists do, because it's probably similar. And they use both of them. Providing geological services, except as specifically exempted by this chapter, include consultation, investigation, including the collection, removal, and analysis of samples of minerals, rocks, fluids, gases, and paleontological specimens, survey, evaluation, planning, mapping, inspection of work in the field of geology, and the responsible supervision of work in the field of geology. That's their definition. No person shall prepare any geological other than a licensed professional geologist or a subordinate.
when you get into mapping again, obviously surveyors prepare maps, now geologists prepare maps, soil scientists prepare maps.
Or stamp any plans, plats, reports, or other documents with the professional geologist, or use in any manner the title. This is what you're not supposed to do. So geologists can stamp geologic plats. Maybe we need to have a representative soil scientist and geologist come to one of our meetings and clarify exactly what they do. I want to kind of avoid any collisions, because they're authorized to do whatever it is they do, just as you are. So, can we do that?
Particular thing here
Okay,
that
on policy number 11, I feel like that the new standards of practice under 0820-03-.06 maps and mapping policy, and I don't think we need it. I think it should.
move.
Okay, we have a motion, do we have a second? Okay, we have a motion and a second to delete policy number 11. All's in favor? Opposed? Okay. Moving on. Policy number 12. I'm going to leave policy number 12 totally alone. It's a very long, lengthy statement that deals with a very controversial issue relative to an Attorney General's opinion. Clearly, this board has stated in the past that they disagree with that opinion, but we're having to kind of live under what the Attorney General has said. So I think policy number 12 should stay because it is of a great service to the registrants to know the history of that particular issue. Hoping that there'll be light at the end of the tunnel one of these days, but we haven't got there yet. But we're getting close. I recommend that we leave policy number 12. And obviously, I guess once we get these completed, they'll all be renumbered so that they'll be consecutive. Right. Maybe just 2 or 3 after we get done. Okay, let's move on to policy 13. We're doing good. We just got about 3 or 4 left here, and we'll get through these before lunch. Okay. Do we have a motion to leave policy 12 as stated? Second? All those in favor? Okay. Policy 12 will remain as stated. Okay. Policy 13, effective immediately, whenever that was, it is the policy of the Tennessee Board of Examiners for Land Surveyors that all recorded subdivision plats and plats of any type or nature should also include, for each individual lot, total acreage, square footage of the lot, or square footage of the lot, and an overall total acreage or square footage of the property surveyed. More detailed information and instructions will be shown in the 2009 Revised Standard of Practice. That's garbage because in 0820-03-06, number 9, it tells how we're supposed to handle reporting areas for properties. So, and I don't, actually our standards didn't even go into effect until March 17, 2011, so the date's all is way wrong to start with. So it's my thoughts that we need to delete policy number 13.
I think you're right. 820-0309.
Yes, sir. Already states what we should do, and that's a redundancy type thing. So we have a motion to delete. Do we have a second? Second. Okay, we have a second. All those in favor? Okay, 13 has been deleted. Okay. Policy number 14. When an applicant appears before the board to discuss a disapproved application due to substandard plats, the supervising surveyor shall also come in. Okay, we have had this instance occur on several occasions. And the disposition of the board has been to file a board complaint against the registrant who has supplied substandard plats and to deny the applicant's application. And we justify that it's 0820-1-.02 under applications. It basically says that the plats that are supplied by an applicant must comply with all applicable requirements of 0820-3 standards of practice. The only thing that this particular policy adds is if that applicant comes to speak to us because their application is denied, is that it says that their supervising surveyor or the registrant who has signed that should come in with them. I personally see no merit in that as long as the board continues to do what we have been doing, which is what the statute tells us to do.
I don't think we need to be trying to make somebody communicate.
That's kind of like beating them up twice. I mean, you've just denied the applicant's application. You've just filed a complaint on the registrant who has sent in substandard plats, and then the applicant chooses to talk to you, and you drag the registrant back in here that you've already filed a complaint on, from the board. I think that's a little too much in my mind.
It's redundant.
Yeah, I really do. I think that we are very consistent in what we do, and I think that we've got that. So I'll let the board chair will entertain a motion to delete policy 14.
So moved.
Second. Have a motion and a second. All's in favor?
Aye.
Okay, good. All right. Number 15. In response to the position statement regarding as-built drawings published by the Tennessee Board of Architectural and Engineering Examiners, as published in Tennessee Design Lines, which is their newsletter, Spring-Summer 2004 issue, the Tennessee Board of Examiners for Land Surveyors hereby submits this policy statement to provide clarification regarding the practice of land surveying. The position or policy statements as written by the Tennessee Board of Architectural and Engineering Examiners does not appear to affect or conflict with the practice of land surveying. However, it has been brought to the attention of this board that certain local planning jurisdictions in Tennessee, citing this position statement, have refused to accept as-built surveys signed and sealed by a licensed land surveyor. The confusion appears to be caused by the lack of understanding of the difference between the terms as-built or record drawings and as-built surveys. Both terms are defined in the glossary of mapping sciences prepared by a joint committee of ASCE, ACSM, and ASPRS. All right, here we go. The record drawing submitted by a design professional is subject to the position statement of the Tennessee Board of Architectural and Engineering Examiners and was obviously intended to provide guidance for due process and responsibility for the documentation of the final outcome of their design after construction is complete. It is generally understood that the contractor usually makes measurements during construction layout as to location and dimensions of the designed structures. This process is subject to the oversight of the design professional and may be relied upon for the record drawings as provided in the position statement of that board. For many clients, a record drawing is adequate. However, with the proliferation of GIS, licensed land surveyors are more often required to perform as-built surveys to accurately geo-reference and measure the features and present the results in the form of an as-built survey drawings and electronic files for inclusion in geodetic databases. These functions are provided for within the definition of the practice of land surveying contained in 6218-102C, and the work product must only be signed and sealed by a licensed land surveyor. Only a licensed land surveyor may attest to the actual measurements made under his responsible charge to such item as location, height, dimensions, alignment, geodetic reference, or references to the legal aspects of boundaries or easements. The licensed surveyor must not offer an opinion as to the matters pertaining to the design or construction, which is the sole responsibility of the designer's professional. Having said all of that, it seems rather clear what they're saying is let's let whoever do what they're supposed to do in that regard, is what it says to me. Apparently at that time the board felt that it was necessary to craft this policy for some local governments or municipalities. I don't have any issue with this particular policy. I don't know its merit plus or minus as far as remaining, but it's whatever the pleasure of the board.
I just suggest that we keep it.
Somebody wanted to say, hey, how do you interpret what have you? This is how we interpret it. You do what you've got.
You have a motion to that effect then?
So moved.
Okay, we have a motion to leave policy 15 as is. We have a second. Any further discussion? All in favor? Opposed? Okay. All right, we'll move on to number 16. Just look. Okay, number 16, TCA 6218-126 authorizes us to do a limited non-monumentation procedure. Let's see here. Policy of this board that all licensees become aware of and understand that these procedures are authorized, but that no standards for these practices are in place. Then it talks about Rule 820-0307, Standards of Practice, which has now been changed. It's policy of the board to consider any survey plat as a general property survey to be regulated under the Standards of Practice. If it is sealed by the licensee, it does not specifically state on its face that survey was done under that authority, 6218-126, and the survey is not a general property survey under 820-03-7. Further, the board will require that any plat or map furnished by a surveyor meet requirements of 820-03-06 maps and mapping. This policy, in my mind, is now greatly convoluted because we've changed the standard of practice. We shouldn't have to tell the registrant that they should have to pay attention to a particular statute or part of their. That's part of their responsibility, part of what they're supposed to do. From the standpoint of protecting the public, the most important thing that's in this is item 1 and 2, that the survey was done under that authority and that is not a general property survey. But if you go back, I think, to our problem with the problem with our statute is it does not direct the registrant to say any of that. So where I'm coming from, I really feel like that we need to keep this policy reshaped, basically to say that the first sentence, the TCA 6218-126, and then it should simply state that the survey should state on its face those particular 2 items. Because I think if it does that, then the public would have the ability to, one, they understand that it's not a general property survey. It's not representing any boundary lines. It's basically a picture. But the surveyor has the ability to do that under the statute. Whereas right now, I know in my area that becomes a very confusing item a lot of times. Well, so I've got a survey, and you look at it and you can tell that it's under this statute, but it doesn't say that on there anywhere. It may use some of these words, such as mortgage loan inspection or mortgage loan certificate or mortgage title inspection. Those may be on there, but it does not inform the public what it's not. That's why I feel like that policy modified is appropriate in this particular application, because the public needs to have better notification than just those few words that's in the particular statute. I think the board would be remiss if we didn't expand on it a little bit.
I agree with him.
Attachments to deeds, master deeds, horizontal property regime. The surveyor may not have his stamp on it. He may not have, but he does. I think the policy ought to state, first of all, like you say, what the statute says, and then I think it should, everyone that does not have monumentation, if it leaves anything off and what have you, the plat should be prepared to the state standards. However, I think they need those two statements on this plat because it is not a general property survey.
Right. Yes.
Policy is just how administratively
Oh, I think
board
that-
policies is
No,
not
I-
going to be a
I
good
understand where you're
communication
coming
tool.
from, Ms. Avers, but I think that what we're doing, better understanding of what the statute says to the registrant, so that in the registrant's practice and procedures, it will create a better understanding by the general public. In other words, I'm not trying to craft a policy that needs to go in the newspaper that every citizen in the state of Tennessee has to read and understand. I'm not trying to do that. I'm trying to craft a policy that explains what this statute is deficient at to the registrant, which will be a positive thing to the general public. I don't question that, because clearly, I think Gail and I both are in agreement, and maybe even Rob, that particular statute should be rewritten.
What is your suggestion? I'm just curious.
Might have to take a month to think of that, or even a week. But, I'm thinking of it like board policies. We post them on our website, and they're really like just almost internal review. Like it takes licensees. It will take us 5 days to process this application. It's not an additional restriction on you. It's not an additional requirement on you. Just it's like, for your information, just wanted you to know, if you turn this in, it's going to take, it's not meant as an additional requirement to laws or rules. It's just like informationally, policies are just.
The registrants in the state of Tennessee were mailed this particular policy, because I've got a copy of it here. So, this isn't the first time that they've seen this, but I think that it needs to remain so that we can reinforce this, because part of policy in my mind is a tool for future boards to be able to look at and see what prior boards have done and maintain a level of consistency for the
I agree. I agree that your policies have been underutilized and underexposed. I think that it should be. That was just maybe a bad example, but I just wanted to use something that would be like.
I understand where you're coming, because we and I think you've seen as we've deleted things, we're sensitive to, we already have rules, so we don't need to embellish a lot of those things. But this is one of the statutes that we have that we need to embellish a little bit.
Policy that no one.
I understand.
Not going to be useful because the public won't. We have. It might be better as a frequently asked question or information for consumers, or maybe policy is the right venue for this particular.
Well, I'm going to differ with you and simply say that in this particular case, we have a statute that is lacking in clarity, and that it is my opinion that we need to maintain this policy in order to have that clarity until such time that that statute is revised legislatively.
I agree with Tim.
In there for
Well, you threw it.
reason in there.
You threw it. We caught it, but it got thrown back.
Okay. I tried. I'm just
Okay,
making sure. I'm just trying to make sure that I can be as helpful to you as I can.
Okay, policy 16, we want to leave the first sentence, and then we want to strike the second sentence. We want to delete the next paragraph and leave the remainder of the policy. If everybody concurs with that, then the chair will entertain a motion. All goes away.
07
Yeah.
goes away.
Strike the where it starts with Rule 0820.
Okay, what about, is the policy the board struck?
Yeah, we're going to leave that.
Gonna leave that.
We're going to leave that along with the 1, 2, and the closing sentence.
Okay.
I so move that we
Okay.
modify the policy 16.
I second it.
Okay. All's in favor?
Aye.
Okay, opposed? Okay, number 17. Primarily is a verification for construction staking and measuring with GPS equipment relative to digital terrain modeling. When we crafted our new standards of practice, we have a section which stipulates all of these particular items. The reason that this policy was crafted was because the board was continually getting inquiries about this particular matter. What this particular policy states is the definition of surveying, and the thing that I felt that was most appropriate, Rob, to be added was the particular section. I have to go back here where I can get the number. 0820-03-.07, paragraph 5. I think that needs to be added to this particular this some when we went through these standards of practice revisions. I think that we need to add that to the front of this particular policy, the pursuant to, and remove activities under review. That's my recommendation, and keep this particular one. This is a pretty big football we deal with. First sentence certainly is conclusionary, isn't it, Rob? Where it says it is clear.
Yeah, that paragraph is.
I don't like that paragraph. because it is conclusionary. Because I would prefer the policies to be opinions or clarifications, not conclusions, because conclusions are pretty firm and rigid in my mind. Okay, so let's look at this policy with this potential change. The first sentence, activities under review, and the colon, delete that and insert pursuant to 0820-03-.07, paragraph 5, remote sensing, construction, staking, measuring, and so forth. The second paragraph I think is okay. The third paragraph is simply our definition. The fourth paragraph, it says it is clear. I think that entire paragraph should be struck. And I don't know that we need to maintain the words board policy because that's what this is. Policy too, Rob? Just the words board policy? Or we need to leave it?
I don't think we need to really have that in there, but in the face of evolving technology.
Because of technology, this is probably our most challenging policy if we want to maintain it because of technology.
Hard to maintain this policy. It'll run out from under.
What's your recommendation? We delete it? Still defend that rule that I stated when challenged. Galen? We have a much stronger rule now than we had before this was ever crafted.
That's the reason for the rule.
Right. Right. Yeah, I mean, this came before the 2011 change. It's now obsolete technically. Okay. Y'all comfortable with that, Sue, Gail? Just delete it?
Give me just a
Okay.
second here.
Sure.
Policies are not vetted with the public. They're not constructed pursuant to a rulemaking hearing or stuff where people could come in and make comments on it. We're just summarily making these policies. That's why you have to be real careful, like Nicole was saying about what's in here. It can restate, it can clarify existing authorities, but it can't create an authority or draw conclusions. We're going to do this if you do that type of thing. That you can't discipline for breaking a policy. It has to be a rule or statute.
Well, that's why I like adding the rules or statutes to the
Yeah.
policies so that it gives them a little bit more teeth.
Well, it becomes an interpretation of what the existing authority is. Just like the 10-year thing, there's a statute. What does that mean? Because there's no case law on it. People were thinking, I got 10 years, I can get a license. Well, no, that's not. And Galen, this has been something he's carried with him for years now. And we finally got it.
Well,
It's like, no, it doesn't mean.
doesn't mean that. No.
This is what it means.
Yeah, I think, having read all of that, I believe that we can delete that because,
Yeah.
5 over there, remote sensing surveys and what have you, I think that's covered under 82.
Motion to that effect then?
So move.
Okay, second? Okay. A motion is second to delete policy 17. All those in favor? Opposed? Okay. I have read policy 18. It's almost 2 pages. I'm not going to read it to you. I really don't know why we have it at all.
Telling you what we already know.
I mean, all it says is that we got 3 categories of getting education for licensure, and it just talks about being what each of those are. I don't know why that we had to clarify those. The one thing I did note really interesting in it, on the second page under item number 4 at the top, it stipulates. I missed that one. That's the PS. I'm sorry, I thought that was it. There it is. It says the FS is 8 hours, the PS is 6. Okay, which that's what they are currently. And then it goes on to talk about what the application fee is and examination fee, and all of that stuff is changing, and we've got stuff in the statute. To be honest with you, I don't understand why it's there. I see it serves no purpose whatsoever.
Like somebody was trying to write a rule in the shape of a policy.
About.
I was on the board.
I have to agree with Tim because I think that everything we have is. Do this because so many things are changing right now, dealing with. You could read this policy and not any part of it necessarily would have.
Okay, we have a motion to delete policy 18.
So move.
Second? All those in favor? Opposed? Okay. Policy 19, I am not going to read. This board crafted that policy. However, we are going to vote on it. If you all would like to leave it as written. And it was crafted by our attorney, so I think it's probably worded pretty well correctly. Beautiful, that's right, okay. Do we have a motion on policy 19?
I move that we retain this policy.
Okay. Second? All those in favor?
Aye.
Okay. All right, we are now at about 10 minutes after 12, and we're at a good stopping point, and I think it's pretty close to lunchtime, so we are going to take a break. We'll try to reconvene about 1:15 if we don't get drowned while we're going to eat lunch. Thank you all very much for getting through the policies, and I think we now have a much improved policy document. I appreciate everyone's help on that. Okay, it's now 1:35. We will reconvene. We were delayed by a slight rainstorm, but we are back. Okay, the next item on our agenda is to discuss the economic impact of the continuing education rule changes. Mr. Herndon.
I'm going to have to change it around. Economic impact statement.
Yeah.
Got the governor's office thing on the back. This really needs to be done after you have looked at the continuing education. Once we finalize this, then we'll do the economic impact. Regulatory flexibility.
Okay. We will so take care of that then, Rob. We'll move that a little bit later on in the agenda until it's after the continuing education process. Okay. Going back to you then, Rob, will be update on the status of rules of conduct.
Okay, those have ended up back from the Commissioner's office, and didn't have any comments on them.
Back to me. I'm going to review them with our chief counsel that's I'd heard on all these rulemaking projects that we've got going, and I'm going to get that approved for a hearing. I would like it to be in August.
I would hope that we have enough window of time to meet all the criteria of the
Well,
days and so forth.
considering I sent it up in October, like now, I thought I had plenty of time before, but I'm going to, now that it's back in my hands, I'm going to do everything I can to get it approved for 5. And hopefully by October, I guess is our next meeting, perhaps we'll have everything. Oh,
Just as an update on rules of conduct, you were in attendance, and I don't know if you heard ML Love's report or not on the UPLG group committee with NCWS. They had been back through rules of conduct, and they have made a few changes. So we as a board may want to look at those changes when we do the public hearing scenario for the rules of conduct, and potentially incorporate some of the new revisions that they have, which will again help us to be more current with our rules.
that's why we have the hearing, so we can get all these comments in and make it the best set of rules we can.
I just simply look forward for this board to be able to have a greater ability to refer to statute and rules when we have to deal.
The need for expert witnesses at hearings and stuff in a lot of cases.
Anything else on rules of conduct, Rob?
No, just
Okay, good. Okay, the next item on the agenda is discuss the TAPS roundtable meeting and questions. We have already reviewed and approved the minutes. They were Donna, you did an outstanding job on those. They were very descriptive of what transpired. This is probably first of many of these meetings to come in the future, or at least we hope so. I can tell you that the response that I have received from members of TAPS has been very, very positive, as much so that a couple of members even made the comment it was the best seminar of the whole program. So I appreciated that comment, of course. But and for Rob and Nicole, which were not there, basically, as you can infer from the minutes, I approached this particular first-time roundtable as being an information for the registrants that were there in the room, so that they could hopefully be a little more familiar with, number one, the faces of the board, who the board was, and number two, some of the things that the board is providing that they may not be utilizing, such as our website and things of this nature. So we tried to be real informative to them. They didn't probably get to ask as many questions as maybe they might have liked, because we really only had a 1 hour window of time. Hard to kind of give them all the rules of the road and then give them a few general instructions and have a lot of time left for questions. So I think that if they ask us to do this next year, which I believe they will, that next year will be more in tune to questions, because I don't think that they'll be as interested in a boilerplate situation that we went through this time. But I felt like that it was important that they knew those things. So my standpoint is very well received. I don't know, Galen, if you had any comments from anybody?
Very similar to what you had, and well received, but I think there are several people that would like to have asked questions, and they just didn't have time to do that. So questions would have been, but won't know until we have another one or have the opportunity.
Now, let's move on to the next item, which is discuss FS exam application review for CBT. This may be one of the most important items that we discuss in our meeting today. We need to determine some scenarios of how we want to allow applicants to apply, how we're going to approve them, because we now have something that is totally unique to us. We have not worked in this environment. 1st, 2014, we will be dealing with a computer-based FS examination. And it'll be administered by NCWS. It will no longer be a part of our standard 2-time-a-year exam week. Tomorrow, the PS/TS will be given, and on Saturday, the FS will be given. Well, the Saturday FS exam will now disappear from that scenario. So there will be some savings to the board because our proctor, Mr. Messier, will not have to stay the additional day and proctor for an FS exam that he will not be given after January the 1st. He understands this. He and I had talked about this prior to his renewing his contract, that during the course of this current contract that he's under, his workload will begin to dwindle. He'll drop the FS off, and then at some point he'll drop off the PS, very probably before his contract terminates with the department for this particular, I think it's 5-year window his contract. That will be a little bit of a savings to the board. The board will not be handling as much money for examinations as we have in the past. Is going to change also, because what we see right now is an individual makes an application, pays $25. Please correct me if I say this wrong, Donna. And after this board approves their application, they pay $125 to sit for the FS examination. The examination, which will be administered at a Pearson View Testing Center, will be $250. That's what it is right now. There was discussion at the meeting, that NCWS meeting, that it may go to $225. Their numbers are still jockeying that. They've not set that. But the applicant, yes, ma'am, the applicant will actually pay that to Pearson View. Now, let's talk about process here just a little bit. And all of these things are precursors to where we need to go with this application scenario. NCWS function in the same manner relative to this exam as they do now, or they have an option. When I say function as they do now, currently the application is made to this board approves the application, the notification is sent to NCWS, the applicant is then able to get on their NCWS website, fill out the appropriate information, they're given a number that they have to have for their test, and then they go take the test. Correct me if I'm wrong. Now, the other side of this coin is NCWS has the willingness to provide the ability to allow the individual to apply to them to take the test without our jurisdiction or our board's approval for them to take the test. However, let's just say that applicant A applies to NCWS and takes the test, okay? they successfully passed the examination. They are not known as an LSIT, particularly in the state of Tennessee, until they make application and we approve everything that they have. So here's the negative in this scenario. The negative is I could apply to NCAAS. I could be in my junior year at East Tennessee State University, and I could tell them I've already graduated. They don't check it. They don't check it. Take the test, I could pass the test. Now I've got my FS with a passing grade, and I can send my application into the state of Tennessee, and this board review that application. I didn't qualify, yet I passed. In my mind, they've created a hardship on the jurisdiction that we would not have had otherwise. So that option, and we'll discuss it further, but that option in my mind is not a very viable option for the way that this board functions with their applications. Part of the enticement that NCAAS has about the FS exam going computer-based is that you can take it any day of the week within a testing window. But part of that bodes around when you get approved to be able to take the test. So some states are doing administrative approval for the individual to take the test. In other words, application comes into Donna looks at the application, if that's what we so chose to do, and then you approve it, send that name to NCAAS, they get their stuff, they take their test, and then you get the stuff back. That's another methodology that we have going on here. So what we need to decide, having said all of that, and I hope I didn't make it too convoluted, but having said all of that, what we need to determine is how do we want to handle FS applications? Because we're in a different environment. I looked at some scenarios. For example, I'll give you this scenario. Let me see if I've got it right here. During the calendar year of 2014, there are 4 windows available to take the FS exam. January, February, skip a month, then 2 months, skip a month, and so forth, all the way through. Could approve, I mean, this is just, I'm just throwing this out. We could approve FS applications starting at our October meeting, which is going to be, like I say, all this is going to be different. Starting in October, approve the FS applications for somebody to start taking the FS exam. Now, here's the key to this, okay? If we approve, let's say we have 10 applications in October, just to pick a number out. If we approve those 10 applications, then come January the 2nd of 2014, they can apply for, once they got their NCAAS, they can apply for a seat to go take a test somewhere at Pearson View. Doesn't have to be inside the state of Tennessee. It could be anywhere. Okay? Now, they can take that test in that first window. Fail it, they can't take it to the next window. Same person that got our approval to take the examination decides, I've got a lot of coursework, or I've got something, I'm working on my master's, and I got stuff to do, and I don't want to take the test until August. Okay? NCAAS looks at their 12-month testing window from the date that they take the first exam. Okay? We approved them in October, and they waited to August to take their first exam. They are good with NCAAS from August to August. That's their 12-month window. That's what they're looking. That's what NCAAS looks at. NCAAS also looks at the ability of that applicant to take that exam 3 times within that 12-month window. Now, Just as we discussed earlier today, by statute, we have a number of two, not three, but two. So again, this is all a little bit complicated. We got to kind of start wrapping our arms around how we want to approach this for, approval, and then when they got to come back and things of this nature. So that's why I'm a little bit against NCWS having the ability to approve it, because I'm afraid they're going to create a lot of problems for us trying to handle and clean. I think from what I heard from several of the boards that were at the meeting, I don't think they were real satisfied with just carte blanche NCWS doing them and then dealing with it after the. I think the first thing we have to decide is how and when do we want to review and approve applications, if that's the direction we want to go. That's number one. How are we going to handle that? Are we going to approve applications at every board meeting? Are we going to give Donna the ability to approve the applications up to the point that she has questions? If she has questions, then it has to come to the board. Cartoon character says, which way do we go? Which way do we go?
These FS exams, when I apply for the
FS is only education. I would prefer the application to be clean so that when it's approved, whether it's approved by the board or administratively, that there's no issue after the approval. In other words, I don't want to get caught in that scenario that I was describing earlier of somebody per se falsifying the fact that they'd already graduated and they didn't.
Yeah.
And the fact that our statute allows for 3 pass educationally to take the examination, and no disrespect to you, Don, certainly, I wonder the merit of even considering administrative approval because of the 3 pass, because that I think would put you in an awkward position of saying, well, this young man's got an engineering degree and he's got 24 hours, so he can take the F. But those 24 hours are in, underwater basket weaving or whatever. Those are the kind of things that I'm looking at. We've also eliminated, the situation of where, a senior final semester is going to get to take the exam. We're not doing that anymore. The statute says they have to graduate. And a senior in final semester is not graduating. There's no guarantee they're going to graduate. So we've kind of. That's where we're at. How are we going to approve these applications and what kind of cycle? Now, as Rob stated earlier, it's unknown and it's probably a moving target. But to get us to where we're ready for applicants to take an examination in January on the FS, I think we need to be, formulating some decisions now so that it can be put out on the website so that the applicants understand what happens if you're going to start taking the exam in January. Fair to the applicants to wait until September or October and then try to start telling them something. Even though the normal applicant inside the state is structured around April and October. Well, April and October are going away. Determine, when we're going to look at these things and how we're going to that first, then we can go to the next step on some of the other issues that go with it. here's the catch to that, Nicole. Even though we're discussing the FS examination, we still are under the same for exam approvals for the PS approval ends March 1, for example, okay, for the window to be able to take the April examination. So we have an obligation to those individuals as well to be able to approve them in a timely manner so that they can register with NCWS, just as we do at the August scenario, because they have a deadline in September. I want to say the 15th, Donna, is in September for the October examination for the PS and the TS. Now, TS is not real critical, but that's the window we use to approve them because NCWS, they're not tied to NCWS, other than the fact we utilize NCWS to certify them to go to the exam site because the exam is given at the same site. And that helps our proctor know that these people are supposed to be there. So that's the other side of this. That's why, you know, when I was looking at this, in February and August, we still have to approve everybody, just like we always have. I was looking at was April and October adding the FS approvals, because what we're going to see probably until this thing gets going, we're probably just going to see, you know, very few applications that we end up hitting each meeting. But you know, the same token, we don't want to delay them a lot either. At the same token, but I'm not quite comfortable with the multiple ways that we offer licensure in our state of just total administrative approval. It's a little bit of a dilemma, but I think we can solve it. But I just have to throw all this out so we can kind of wrap our arms around one part of it at a time, and then once we get all the components put together, we may see that maybe we need to change one of those components so that it works with all the others. Because, I mean, theoretically, you know, FS exam last time, Donna, you remember, what was it, 20-some, or around 30 at the last exam? I didn't bring my notes on that. I know in the minute, put about 20 approved in the applications that were approved for the April exam in the minutes. But again, you know, the fortunate thing for us in a way is that we're not looking at huge numbers, no matter how we progress. And I don't think that we make it unfair to anyone by not approving them immediately, because part of the situation with Pearson VUE is Pearson VUE tests many different professions, nursing, accounting, etc. And because they do that, their testing centers are generally small. And very possible, I talked with Davey McDowell with NCWS, and he says it's very possible that you may have a week to 2 week wait time to get your seat if you want to sit at that particular center. Because you see, it is a 6-hour exam, so you're basically taking that seat in that examination center all day. So whenever they give you that seat, you know, they can't use it for anything else. Unless
flying to California to take the test and then coming.
They would have to, as I understand it, they would have to apply to NCAAS a state that allowed NCAAS to approve their application to take the examination. That scenario, it goes back to where I was talking earlier. We then, if they came to apply to take the PSTS exam in the state of Tennessee, because that's where they lived, if they passed the exam, we'd have to review to see if they met our qualifications. Entirely possible that we could tell them that they did not meet our qualifications at the time they took their examination. And that's one of the hurdles that NCAAS is going to have to address, because I talked with Regina Dinger, who's the executive director for Alabama, always on top of this stuff, and she sees some huge problems with this scenario. And of the Southern Zone people that were there, there's not very many of them that were real fond of this carte blanche approval and letting NCAAS take care of it.
Actually, I could see,
Well, to NCAAS, that's the beauty of once you are approved, you can take it in any of 400 and some Pearson VUE testing centers in the United States. That's the beauty of it. If you're in Florida on vacation and you decide, hey, look, I'm going to go take this test tomorrow, you can go do that, okay? And that's fine. My heartburn is not being able to approve who or what they're saying they are at the state level before they go take that, and then have to. It's kind of like asking permission and asking forgiveness. They go take it under some circumstances that we're not comfortable with. They're coming back asking for forgiveness. Whereas I prefer that they ask permission, and then once we allow them, then they already conform to who and what way we do things, and we should have less problems that way.
On rules here about applications. So currently the board approves an applicant to take the examination. The way the engineers used to do it. But now, with the computerized fundamentals, the applicant applies directly to NCAAS and takes the exam. I was looking to see if we were required to approve them for the exam.
I know I talked with John Cothran, and John told me that his office does administrative approval for however, the situation with the FE exam is it's much cleaner for them because they basically have one route to licensure. It's the BS degree or the BS degree or the BS degree, with no baggage attached to it. We have the same thing, except two of those three's got baggage, depending on which criteria you fit in.
All three have to take it, though, don't they? All three categories.
Take it, that's right.
No matter what, they got to take the FS.
Right.
And then we have to get that score and then plug in the rest of the stuff. Go ahead and let NCAAS already, are you not trending that way? Of administering the schools certify to NCAAS that this person can sit for the test.
That's the problem. They're not going to do that. That's the fallacy in the NCAAS.
Yeah, well, everybody seemed to be talking about that anybody could take it.
Right.
So the schools, the engineering school deans were here yesterday. They were discussing on ways how they would prevent a sophomore from taking the test just to get a look at it. That exam score would not count toward licensure. They're trying to anticipate all the different things that could happen here. Of course, security is not a problem because now the test will be so infinitely any good to sit there and try to memorize it and try to sell the answers. Had to approve them for it by reviewing their materials.
Our application, I think we need to do some modifications to that for this problem. I'll speak to that in a little while, but like I say, I'm just trying to wrap my arms around, let's structure some type of criteria to say how we're going to review them and when. I think if we get by that hurdle first, then we can gravitate into some of these other situations, because the next situations deal with statute relative to 2 failures. They're going to have to reapply that we just talked about earlier. This recommendation is 3 failures. The statute of the 1 year window, good for the application, things of this nature. We'll get to those, but I'm just trying to get at, let's figure out how we're going to approve them first, and then we can get to the details of the approval. All right? That's just the way I've got this structured in my mind. If I know when and how, then we can get the details to get to there.
I was looking at Rule 08-2001.
Board members recommend examination of an applicant. Such examination will be looked at the authorities, and the authority is 105D, which is our rulemaking.
The way that has been utilized at this board is that if necessary, if there's only 2 board members present, 2 board members can approve applications, as different from a majority, having motions and so forth. It's always pretty well been looked at. I'm going to just throw something out for what it's worth. I would like to try to start in October at our schedule. Approve FS applications would be in February. In other words, stay on our current quarterly meeting process, because now think about this just a second. If we meet, let's talk about February. If we meet the second week of February, which is first or second, which is when we've been meeting, okay? March is dead, okay? NCAAS is telling us it takes 1 to 2 weeks to get a seat. Early February, chances are they may not even get a seat in February if they were approved, okay? So March is dead, so a person getting approved in February is probably going to be available in the April-May window anyway, just by the logistics of the scenario. Everything went according to Hull, and we approved them February the 5th, and that was sent on the 7th or the 8th to NCAAS. Then they got on the computer and applied by the 10th or 12th. Then they got a Pearson VUE seat. Yes, they could potentially probably have the exam taken by February the 24th or something, in that scenario. So, they could potentially get on with it if that's the mode that they looked at. And then coming off of a dead month, we could approve in April at our April meeting, and they would still be allowed to, take it shortly thereafter or all the way up. Part of the process is you have to understand they don't have to choose to take it immediately. They can wait. Take it and let their buddies tell them what's on it or whatever, and then they'll take it 3 months later or whatever. Then August is the same situation. Immediately following August is September, which is a dead month. Following October, the October meeting, of course, is the December's the dead month. In that scenario, I don't see we're adversely affecting any applicant, because I don't anticipate, because like I say, I think, and I know you don't have your statistics, Donna, but I think in a calendar year, we've not been looking at over 50 FSs. If you spread 50 out over 8 months, you're only looking about 6 in They have not said in any of the, whether or not what they're going to do if a jurisdiction applicant is only allowed to take 2 exams. They've not said what they're going to do with that. I don't know how we red flag that. That's one question that has not popped up that I've heard. Everybody's trying their best to conform to the way they're structuring this thing. I mean, I'm just trying to get us a calendar going here, and then we'll start getting some of these details.
Do it every meeting. I think. Had somebody come in here, like said, Greg went and took the test. Do turn him down, make him go take.
Like what you referred to in the sophomore taking the exam, and then try to pass it off as, hey, I've already took it.
Authorizes you in that particular year to nothing to prevent somebody from doing it. It's just it won't count.
I just really need to.
Yeah. We'll take about, what, 5 minutes, 10 minutes?
And I could really use chocolate.
Turn the TV off, Donna. We're going to take a little break.
Please.
Yes, ma'am. That's fine. That's fine. Okay, I think I thoroughly confused everybody with my little disarray on dates and times, but hopefully we've all decompressed and we're ready to go back to this adventure and see where we're at. So I think we're going to let Miss Nicole address us if she's ready.
Sure. On the sheer speculation and conversationally,
Okay. I don't necessarily question that, but I would ask this question. What if we received an application from an individual that had a degree in geomatics from the University of Florida?
Well, that wouldn't be a
Category,
application.
that's a Category A. But I realize that the two primary universities in the state of Tennessee that we allow their graduates to take the examination is UT Martin and East Tennessee State University. UT Martin is actually in agricultural engineering, I think is correct, and East Tennessee State is in geomatics or surveying. So, you know, we could say that, but at the same token, we have always reviewed the coursework for UT Martin very closely. ETSU conforms to the spirit and intent of what we all wanted for a BS degree, but all the other universities don't necessarily conform. That's why I have a little bit of a concern about that. No disrespect to your concept, but I think that we would be showing some level of favoritism if we said, okay, for UT Martin, ETSU, you show up with an application, $25 and a diploma, you're in. You know, administratively you're in, and anybody else, any other form or fashion, the board's got to look at it.
Right. If it was just a degree.
That's where we differ from the engineers. You know, whether you get a degree from University of Tennessee that says in civil engineering, or Vanderbilt University that says civil engineering, or the University of Alabama that says civil engineering, it says civil engineering, and they approve it and they move on. So that's where we're different. And I wish we weren't. I wish it was more uniform. And that's part of one of the underlying goals of NCWS is to try to get the surveying profession much more uniform out of all these deviations and variations and problems, so that licensure from jurisdiction to jurisdiction is much easier, and it's more on the same plane, similar to engineering. Oh, that's fine. No, that's fine. That's the whole purpose of this. That's the whole purpose of this discussion. There's no wrong thing to say or whatever, because we're just trying to craft something that, you know, we got to start pretty soon, and not only do we have to start, but we got to notify. And that's why I want to try to get the bugs out of it at this meeting if we can, as best we can, knowing full well that as time goes on and this thing begins actually evolving and happening, that we may have to tweak it. And I don't have any issue with that at all.
A couple of things that I'm thinking of right here. Have in place right now a review process that we use, and my concern after January the 1st, somebody could walk into the Pearson View Testing Center and say he's from perhaps ought to start in October, and we still have the appropriately, but maybe I think we ought to kind of slow walk.
Let me correct one thing that you said, Galen, if I may. No one is going to go into a Pearson View and give them information. They have to authorization of NCWS. So if someone falsifies or whatever, it has to go through NCWS.
Okay.
So actually go to Pearson View to take the exam, you'll have a piece of paper with a number on it that says you're approved by NCWS to be there to take this exam, and you will have already scheduled so that they know that number 4, 5, 6, 7, 8, 9, 10 is coming in on Wednesday, whatever date it is, at 10 a.m. in the morning. And this is going to be your seat, your cubicle, your computer, and they'll already have it ready to go that when you come in and sit down, they can push a button, and that computer has your test on it, and you're off and running, because that computer actually has to tie to NCWS because of the nature of the exam, it being linear on the fly. Yes. And somebody from Clemson, South Carolina is going to trigger that test, and then those questions are going to start rolling into that person. Yeah. And do it from there.
And that's okay, and I understand, and I think that's good. I still think as far as the board is concerned, I still think we perhaps ought to review.
Oh, please don't misunderstand. I agree 100% with you, but I felt like it was appropriate for all of our administrative staff, attorney, and all of us to know what all the options are out there.
Yes,
so that we can explore those. But I agree with what you're saying 100%.
Okay, as long as
we're on the same page.
Okay, and that's fine. I tend to think state legislatures, they might, not necessarily in this state, but I know other. October ought to be the time that we review. When will be the next review? I'm not sure what we. Order.
Well, what I was trying to establish here was if we could establish, let's pick a routine, whatever it is, if it's wrong. Let's pick a routine, because my concern is Donna's got to put it on the website and let folks know that, hey, this is the new routine, this is the new deal. And we're going to see that more so in a minute when we talk about this application. So if we pick a routine, we can get it published, and then we can start it. But with the understanding that if we get to, for example, the same meeting next year in April, and we have tried to do something in October and tried to do something in February, and we're uncomfortable with it, Donna and Nicole, they're having issues with it, then, hey, we need to throw up the red flag and say, hey, wait a minute. Yep. Let's see what the problem is. Let's see what we need to do to tweak this. Let's make it better for everybody, because, that's my goal, is for their job to be simple.
Yes, agreed.
So that's kind of where I know where you're coming from. You're right.
Yeah.
I'm not trying to set a schedule for the next 20 years.
No.
I just need to get something going.
Let's get something going.
Get something going so we can try to get someplace. Okay. Get to square one and then see what all these obstacles are. Mm-hmm. That goes back to the narrow window. If it's approved in October, which would be the last weekend of October, I don't remember our dates exactly, but it's right at the last weekend of October. That short window of time that we talked about before, they have the full month of November to take the exam. They could go through that process that we talked about during break. The Monday after our meeting, Donna could send the information in. The applicant would be notified by Tuesday or Wednesday after our meeting, and then it's up to them to, once they get their notification, to fill out their appropriate paperwork and request a Pearson View seat. So it could be entirely possible that we approve an FS examination applicant in late October, and if they so saw fit, because they were in a hurry, they could be taking the test by, say, the second week of December, or November rather, second week of November. So If they really want to get after it, they could get on it right then. But if they missed the November window, it would be January before they could take it. But we certainly would be at making it available for them to take within the next 30 days. And like I say, with no larger quantity than we have, if we were wearing the shoes that the engineering board wears, where they have typically 500 or more applicants per April and October exam for the FE, and we were looking at that kind of volume, then we would either have to have administrative approval, or the board would have to meet every month, or something would have to be different. But with the volume as low as ours currently is, I think that some type of schedule like we're talking about right now, in its infancy, will do the job. And we'll still have the appropriate review and control of the application that I think we all agree we need to have, so that we don't have a lot of these problems that could be out there. Okay? So, having said all of that, let's go at it this way, Galen, and see what you. For the first first 6 months of 2014, let's establish a criteria of approving FS exams this October 2013, FS in February, and FS in April.
Okay.
That would give us enough time to see how we're doing.
Okay.
Would that be fair?
That gives us an opportunity.
Give us the opportunity to see how we're doing.
Whether we're behind the power curve or
Right.
if we're well on top of it.
Right. Either way we can adjust. And that'll give us, because I really feel like that by February, when we get to February, I feel like that we'll be beginning to have a better feel for where we're at.
How many applicants are we getting?
Altogether, or just FS?
FS, just FS.
Oh, there's not many this time.
There wasn't like 30-some total to take the entire test, all three parts.
Fundamentals, maybe.
Larger number.
Usually, that fundamentals in Tennessee are usually the larger number. But
That number by doing this particular thing.
August, we'll review all. October, we just review FS. February.
Motion to that effect. Let's make a motion to that, just so we've got it on record. All's in favor? Aye. Okay, all right, that's the plan. Now we have a plan for how we're going to review, okay? So that's good. That's step one. I wanted to get that step behind us. Okay. Now, next part of this equation is going to be discussing the application revisions for the FS exam. Donna should have laid in front of each of you a blank copy of our application for professional land surveyor in training. I would like to spend a little bit of time on this application. And tied with this application, Donna, we need to begin to craft some language to go on the website that addresses our FS approval process. Or CBT. That is something that's going to have to get put together and get on the website, I would think sometime June or July at the latest. Because we'll have to. Also, the other thing is, I need to ask this question, Donna, when we're talking about crafting this language. Currently, we are using. Let me think now. If we're talking about a February application, we're currently using January 15. Okay, so if we're talking about an October FS exam, we'll talk about September 15. What I'm saying is, you need to consider what the deadline is for each of these new windows we're talking about. You have a current deadline for the February and the August meeting for exam review, exam application review, but you do not currently have an April. Part of this that we publish on the website, because like I say, this is going to be a little bit of stumble along the way here, because getting everybody used to the no longer April October exam.
And I have a question.
Yes, ma'am. FS will be immediate registration.
Okay.
They are not going to have the same deadline that they do for the PS, because the PS will continue for the short term on the April-October. Question. It's a good question, but they're making it immediate. Everybody thinks that, for the boards that do administrative approval, that they can get approved today, NCEES this afternoon, and be taking the test tomorrow. It's just not going to quite happen that fast. Even though, once you actually sit for the examination at a Pearson VUE site and your results will be back to you, they're saying right now 48 to 72 hours. Passed or failed.
And they'll email that directly to
the applicant and also come to the board. Because in the application, in that format, they have to check what state that they want it sent to. That's part of. They're going to do some demographic analysis with. That's why that they won't like us. They suggest that we do our state specific through them also, because they can look at the demographics of how many people. Trying to get more data so they can see trends and all. Okay, all right, let's move on to the application. We'll start at upper left and work our way down. This is Sue and Galen's favorite part of the application. It's the picture. Going to get good pictures, or we're not going to have good applications. I'm just going to say that, and I'm not going to stereotype or anything of that nature, but we're going to have good pictures, or we don't give a good application, right? Sue agrees with that, and so does Galen.
Amen.
All right, let's look and see what this thing says here. No, there's not. That's
This has to be on the
Yeah, it has to be on a form. Like it, that's discriminatory to have a picture. What you're saying is the state of Tennessee is doing a new online system that all applications will be done online and won't be manual, such as this?
Not saying to have,
Yeah.
but I don't know if you can if you don't have authority.
I'll be honest with you, I mean, in lieu of a photograph and of some of the type of photographs that we have seen and have gotten, I would prefer to have a copy of their driver's license as in lieu of the photograph. Reason being is that's a form of identification that's utilized to allow them an examination to start with. You know, I would rather see that myself. I don't see anything, and Rob, go through this application with us if you will, please. I don't see anything offensive or changeable or whatever in the first paragraph. Basically, it just tells you that, you know, the board is going to let you take this test and you can't practice surveying, and these are the statutes that applies to it. That's what I see. And if you pass the test, you'll be acknowledged as a PLSIT. Currently, Donna, is this application, does it have the ability, because I've not filled out one obviously in a long time, does it have the ability to be filled out on the internet and then just printed? Okay, so it would be legible, more legible that way.
It's supposed to be, and yeah.
Okay. All right. Okay. The second paragraph just basically tells you what you need to do. Okay, now in the second paragraph, here's something I'm going to jump ahead and want to discuss. One of the items I'm concerned about with this application is where in the second paragraph it says all references are not provided, this application will be returned. I have an issue with an FS applicant providing references. Classic example. A student at East Tennessee State University wants to take the FS exam. Sends a reference form in from Marion Clark, who is a professor at East Tennessee, now it's Young, Marion Clark Young, at East Tennessee State University. She copies the same reference form over and over and over that says this person is a student, test, I am, and signs it. I see no earthly purpose in that whatsoever. Atypically, the only people that the student is going to be able to have references from is going to be an instructor, and the instructor has no idea whether they can survey or they can't, even though they're trying to teach them. Now, that's my nickel. I see no earthly purpose in that portion of this application. I'm concerned when that person gets this, passes this FS, and is in that progressive experience period, I'm concerned what those people tell me. Because that's going to tell me whether or not we got somebody we want or we don't. I think we need to strike where it says, and I really don't know. Let's speak to the university statement there also. I think that whole thing needs to be struck because it says if complete addresses for universities are not provided, this application will be returned. Well, on the second page, it says you must submit a certified transcript. If it's a certified transcript, I don't care if East Tennessee State University is on State of Franklin or if it's on Main Street, because it's going to say on that transcript where they're from. So I think we need to strike that. Move on. We'll make some strikings here, and then we'll do some motioning in a little bit. Okay. Do you actually still take money orders, Donna? Does the state allow money orders?
I don't, yeah, they allow money orders, don't they, Nicole?
Accompanied by a check or money order. What about credit card payments?
They will.
And I ask that because, you know, when we renew our license, if you want to pay credit card, they got that fee on there I don't like.
You can only renew online right now.
Asking.
Let's not create a
No, I don't want to. I just want to say, you know, if that's part of the system, let's utilize it. If it's not, we won't worry about it. That is still $25. That's what's stipulated by statute in our fees. Now, your address is going to change, is it not?
No, everything's going to stay the same. The only thing's
With payment. Here's where the puzzle comes in. This application along with the $25 application fee, and we're going to eliminate all reference forms, education verification forms, and we're going to eliminate that too, aren't we? Because all we need is a transcript. We just need a transcript. Must be received by, this is the key. Now, it no longer applies what it says. How do we address that? Deadlines no longer apply. Those two may, do we add others? That's the question. That's why we went through this other adventure getting to here. Why don't we say 30 days prior to board review? And when we do that, then we put this calendar that Nicole is referring to on the website. Think about that, Mr. Cole. I think we're going to have a calendar. I really do. I mean, other than, you know, right now we have basically a verbal calendar on the pull downs in the website. But I think we need a picture calendar.
I think ultimately we will have a
Do you feel comfortable that we could say 30 days prior to board review? That gives Donna a deadline, and if it's in there by then, 30 days prior to our meeting, we can look at it. If it's not, it'll go to the next meeting.
I don't know that any of
That makes sense. That makes sense. If we put the information on the website,
Right, and then.
I don't have no problem with that.
In 24 hours?
Yeah, I don't have no problem with that.
Yeah, I mean, ultimately.
Okay. So after the line that speaks to the address, we'll just delete the rest of it. How's that?
Yeah.
I don't have no problem with that. I mean, that's what I'm all about. Is let's get this thing as simple as we can.
Do you want to delete the please allow purpose of using?
Let's go down to the information part then. I'll tell you what. Let's stop right there. Let's stop right there, and let's do a motion to clean that part up, and then that way we can work our way through the rest of it. Right now, what we have is we're eliminating the last line in the second paragraph, starting with if complete addresses.
Second paragraph.
Second paragraph, yes.
All right.
right.
The last line.
The
only.
last
Let's
sentence,
start if.
the last sentence that starts
Last
if
sentence.
complete addresses
Yeah.
will be eliminated. The last paragraph, we're going to eliminate a check or money order and put in the word payment. We're going to eliminate third floor from the address because apparently you'll get it without a floor, right? Okay. So we're going to eliminate a floor. Is the zip code correct?
Yes.
Okay. And then we will eliminate the last two sentences of that paragraph, starting with this application to the end. Everybody is in concurrence with that. The board chair will entertain a motion to that effect, and we'll get that part of it out of the way.
So moved.
All those in favor?
Huh?
Aye. All right, now let's get on to the meat and taters of this thing here. Okay. Is there anything in this, at the bottom of this first page, that we're asking here that we're not allowed to ask? Because I know the rules are, it's always a moving target. I know in my business, my employment application has to keep constantly changing because anymore you can't ask all these questions. We do. Our statute says they must speak English. It sure does. Believe it or not. That's one thing I do know on the application. It says that they must speak English. Now, I put my finger on it exactly. Much?
6218 109.
109, okay.
Right.
I knew it was in there. I just couldn't figure it on stat. Thanks, Donna. Okay, so I think we're good on the bottom of page 1 then. All right, let's go to page number 2. While we're looking at the top of page number 2, I have a question. My question is it a problem, an issue, or whatever to part of the statute? I know.
Ask if they've been accused of, if they've been,
But we do ask if they've been convicted of a felony. Okay. Because I know it says they must be of good character and reprobate. Just want to ask, because that was brought up in our, I believe it was the Surveyors form one day when we talked about it. It was brought up that there were some member boards that actually take their applicants through a criminal check.
hard to justify that. And
I mean, I wasn't trying to look for something, especially cost-wise, wasn't trying to create no more cost or nothing of that nature.
One thing that you'd never think about, but it's just so onerous on the app.
Oh, that's fine. That's why I just wanted, that was more of a information thing for me than anything. And thank you, Rob. Okay, the first one deals with disability to take the exam. That's important to know. Pearson View makes ADA provisions and so forth. They went over that. No, we need to know this. This is for us.
But do we need to, are we?
Actually, that's actually a good question because I tell you, that came up. Remember, Peter talked to us about that.
Yeah, we had an applicant that took a test that was had a. I went down there and saw the individual.
He wasn't actually an FS applicant, but that's a good point because this going CBT, we don't need to know that anymore because we're not administering it. Pearson View's the one who has to administer it, and that is part of the NCEES application. Determine if they need, for say hearing or a wheelchair or whatever it may be, whatever the disability may be. That's a good point. We could eliminate that. Certainly. Not for this exam, but this is only for one exam, and that's the key here. So let's eliminate F then. That's fine for right now, and then we'll vote on these again here in a minute. Okay. Okay, application for the board. Been disciplined by any state licensing authority. Now, the only way you'd have been disciplined there, well, would have been unlicensed practice, but it could be, this says any state licensing authority. It could have been you tried to do something else, maybe engineering or something.
Hairdressing.
Yeah. Have you ever been denied registration or had your license suspended or revoked? I don't know why we asked that question. Because this is a person taking the very first part of the examination, and well, wait a minute. Let's back up just a minute. What if that person had had their license revoked
In another jurisdiction.
in another jurisdiction? We couldn't allow them to take a test anyway.
Or another type of license? You'd be surprised how often.
But if that was the case, it'd be better if we said a license instead of your license. In other words, they could have had a license revoked, for example, in engineering.
And again, it's redundant considering I above it. Have you had a license in something else?
That would cover it, wouldn't it? I mean, the one question would cover both of them, wouldn't it? So let's eliminate J. What do you say? How's that, Robert? Okay. All right. We're going to get rid of J and use I, because I says any.
Well, let's see.
I only says has you been disciplined by a licensing authority. It doesn't say whether the license has been revoked. Would it cover revocation and suspension? Discipline would cover revocation and suspension. What about other forms of discipline?
Civil penalties, anything that officially or formally.
that covers it, then there's no sense in being redundant. But if it doesn't cover it, then maybe we ought to have it in there.
If somebody surrendered their license, they may try to get.
I will cover what is in J, then let's just use I and eliminate.
Felony, which felony wouldn't allow them to take it anyway by our statute. So that needs to be answered. So let's stop here. And looks like we're eliminating F and J. So the chair needs a motion to do so.
So moved.
Second.
All's in favor?
Aye.
Okay. All right. So now we're down to item number 2. Item number 2 basically asks for the applicant to submit certified transcripts with their application. Now, this is where I have heartburn. It says you must highlight or list on a separate sheet attached to the transcript all surveying-related courses that you are claiming for credit under the provisions of TCA 6218-109 for eligibility categories B or C. I think that that form should be part of this application. Not at with this application. It is, so it's right with it. Okay, but it's not. In other words, what I'm saying is, when you pull this form, is that form there?
When you pull up, because these are separate in the,
Right.
there's the application now that's on there. There's the application, the form. Don't scroll down and it's all there, but you go to different links. I mean, it's right there.
What I'm saying is, because this is where we really want that information, wouldn't it be better if it was actually part of this document without having to scroll down? In other words,
Right, when you print it all off, it would all print off at the same time.
right, that's what I'm
Right,
trying to get
right.
at. Can we do that? We can do that, that would be
We'll have to
good.
change this and take the old application off and do all that, and then we could,
I'd like that just to be a part of it, because that always it becomes an issue when we're reviewing applications. We have to go through and figure out and write down on a scrap piece of paper and all that. We don't need to do that.
yeah, no, I'll tell you. Not just this one, but the other application. If they don't send that form in filled out,
I'd just like it to be able to be part of this. In other words, if this application ends up being 4 pages, that's what it ends up being.
all they're going to need is their application, their transcripts, and that form.
Only need the form if they're applying under B or C. And it's the only place on this form that tells them about B or C. We don't, on the regular application, it says category applying under, A, B, C, 10-year. What I'm getting at, because speaking to something here that we've not previously addressed is what I'm getting at. That's why, another reason I've got a little bit of heartburn about it. Oh, what we're talking about is actually a blank sheet of paper that you fill in the blanks. All we need to know is which category they're applying under. And as soon as you see B or C, you know they got to have that piece of paper. Okay? The rest of it is just fill in the blank relative to wherever you went to school. I think we're good on page 2. Now let's look at page 3. And I'm going to say that on page 3, I would like to eliminate references. Particular exam because the criteria is strictly educational for this exam. The experience is out. I'm not sure what any of those folks could tell us, because that's enough. The rest of it is just basically an attestation by the examinee that they're not going to practice surveying if they do pass this test, and that what they said on their application is true, basically, and it's notarized. The chair would entertain a motion to eliminate item number 3 for references. Okay, so now we've made great progress. We have a tentative calendar to review these applications. We have decided that we want to maintain the ability to review the applications, keep it in our control. We now have a modified application, and we will be in the process, or Donna will be in the process of getting information on the website when this stuff's going to happen, and getting this application modified to be up to what we're looking for. This should simplify our review of an FS candidate greatly. The only ones we'll really have to scrutinize real close will be the category B's and C's. Leave the picture. Yeah. We did leave the picture.
Yes, we did.
E's hanging around here. This Galen brings up an interesting point, and I'm going to let Rob speak to that. I know at least a year or so ago, Rob, we talked about changing because of the format for the examinations, and I know you have crafted a document for both the surveyors and the architect engineers.
I don't know how they select bills to put in, but I sure put in the.
Got theirs took care of?
Yeah, and I don't know if it's because, I submitted.
My opinion, my personal opinion, that whether we get that change made or not in the statute, because we utilize NCEES to provide the examination. Their judgment that a 6-hour examination, computer-based, tested, is equivalent to an 8-hour written examination, then I think we have to. That's kind of my opinion. I mean, that may not be the best way to go around the barn, but that's the way I see we need to go. Hopefully there won't be much of a gap between. Even at that, I don't see that it would be, I don't see how this board would be in a awkward position to have to deal with that scenario.
Have absolutely no authority now, because now the exam's 6 and their statute says 8 because of the model language, and surely NCEES was aware that all these states had the 8-hour stipulation in all their statutes. I mean, I would think that they'd provided for that to make it equivalent to the 8-hour. I'll get it changed next year for sure.
Yeah, that's kind of what I think. Okay, so just as a quick review, anybody have any other questions relative to CBT? I don't know that we've. Not naive to think that we did a perfect job and it's over with. By no means.
There's that great unknown about how
Right.
Applicants are going to react to it.
Okay, well, that's good. I think we had good spirited discussion on that, and got a course of direction, so I think that's important right now. I think we've seen. Okay, let's see. Okay, the next item on the agenda is discuss the Southern Zone meeting. What, Donna? Oh, the board presidents?
Yeah.
Oh, okay. All right, let me go ahead and do that. That hopefully was in your all's package. I attended the board presidents' NCEES meeting in Atlanta. It was in time flies. Basically, they gave some more CBT definitions and criteria and so forth. We went through quite a bit of information on that. They've done a really good job about trying to be very informative to all the member boards and anybody else that wants to. One interesting thing about it in the report here is that the exam time will be 6 hours, and that 6 hours will be made up of a 10-minute tutorial when you first come into the Pearson View Center. Have an exam window of 5 hours and 20 minutes, and that exam window is basically timed. So that's the window. So what that means is you can take a break at the midpoint, about 55 questions, somewhere plus or minus right in there. But two things about that break, or three. One is when you break and you shut that computer, push the button on that computer, everything that you've answered is now went to NCEES, and you can't go back and check it no more. So when you shut that puppy down right there, that's gone. So you can't go back. You don't actually have to take the break, other than maybe to go to the bathroom or something and come back and sit right down. But you have up to 25 minutes for a break. You can go outside and smoke or eat a sandwich, whatever it is you want to do. Okay. Then when you come back in, if you, for example, if you took 4 hours and 20 minutes for the first 55 questions, When you come back after your break, you got 1 hour left. That's it. So you have to work pretty fast, I guess, on those last 55. And then after you get done with the exam, they have a 5-minute exit survey, just basically to get your opinion, what you think, and which I think may not be the best time to ask somebody if they're whipped on this exam. But that's the structure of the exam. And part of how they got to that, I was on that committee, was the current exam was taking 8 hours. But you had to be there 30 minutes before and go through information, credentials check, all this kind of stuff. There's a lot of stuff you had to go through with. Then you took an hour for lunch between the 4-hour sessions. So what was known as an 8-hour exam was actually taking you better than 9.5 hours to take. So that's kind of where they got. They actually took a 9.5-hour exam and scrunched it down into 6 hours. And that's part of changing the questions from 180 to 110, of which 10 are what they call pretest questions, which just means they're in the mix. You don't know which ones they are, and you take them, and that gives them statistics to tell whether they're a good question. They begin running those questions in and taking others out, is the way they work that. The other thing was, again, they were just simply encouraging member boards to do just what we're doing. We talked about rules and statutes. We talked about process and applications for the exam, how many times the applicant can take it, approval. And here's something that was brought up that's important, is possible restructuring fees the board charges for the application or the exam. So that's something that I'm sure at some point in time we're going to need to look at again, maybe, because our revenue expense stream is going to change with CBT. Not only do we lose the fee for taking the exam, we don't have to pay the fee for them grading the exam, nor do we have to pay the fee for Peter administering the exam. So that's my board president's report. It was a good meeting. I think there was 40.
All I can say is I didn't know. I was ignorant on something. They told me that there was a 3-page booklet on what acronyms they had. I didn't have access to it, so all I could do was answer the ones that I knew. So.
When you go to the national meeting in San Antonio, if you get to go, the front of that page is telling you what all those acronyms are. And that I've never been in an organization in my life that had more acronyms than NCWS.
You need a translator.
at every meeting, but it was discussed again. There was
Takes the applications, they don't review every course, by the way, that comes in. sit down and look through and say, oh, this silt is as good, whether it's a 5.
All they do is approve the vendor for a fee, period. Doesn't.
Quality enough for us to take, be it business management or surveying or.
Correct me if I'm wrong, currently we only have 2 members, do we not? So our board. Roberts and Bart Craddy. Gets don't you get a duplicate of everything they get, Donna? Have you been?
Runs in spurts too, doesn't it?
I know I talked with Gary Thompson on North Carolina board, and an application. They approve you, they charge you $100, and then once you're approved, they still review some information, but basically there's no fee the second, third, fourth year right on down the line.
Florida has a renewal fee every 2 years, and I think Virginia.
Our new business portion. At this point, I want to ask Donna a question. Tomorrow's agenda. discuss with these applicants. Rules, which I'd like to leave that for a regular setting so we can start that fresh. What time are these individuals coming in, Donna?
I think they start coming in tonight.
Probably what we can do then is let's leave, if it's all right with the members, let's leave our two old business items for tomorrow. Rob, can we go ahead and get on to the continuing education? Notice there was was there not one other document on the iPad here?
iPad, you have like the rough draft that's still got the red lettering and stuff in it.
Yes, uh-huh.
This document is that. I've just formalized it into the correct
That's what you
format.
did here.
Yeah.
Took the red letters out.
All the red stuff is underlined
Yeah.
because it's new, and everything is struck. This is the document I want you to review and approve.
Other one on here, there's two of them, yes.
This is the form I want you to use. It's got the two sets of questions.
That's the reason I asked, because I knew there was two on the iPad here. One
Sorry
of them
about
had a
that.
whole bunch of breakdown on it.
Yeah.
We're going to talk.
Talk about these two head trees.
What's the primary thrust of regulatory flexibility? Is it dollars or?
It's dollars, and it's making things easier for small businesses.
In other words, anything that we do, we have to analyze its impact. License companies. We don't though. We have to make them register with us. But we've already talked about that in the document for the other set of rules.
We want to go ahead and get that step out of the way, such that if there comes a time that there needs to be a fee, that part of it's already out of the way. Just a matter of changing.
License, but that's how we as a board keep up with who's working for them, registrants they have working for them, and who's in charge of that office, and so on.
For our meeting in the morning, could you get us a couple of numbers? Acres for April and October of 2013. Does he be interested to see that also? If he does. Hopefully that won't be too cumbersome on you to get that data. I think that'll help conclude our Okay. Anybody else have anything else that they want to discuss? And if not, we'll